Ladies and gentlemen, thank you very much for coming tonight. Before we come to order, I just want to make a quick little introduction. My name is Todd Smith. I'm from Library Municipal Law. I'm the City Attorney for the City of Lexington. I appreciate y'all being here tonight. This is not a court of law, but we're going to maintain courtroom decorum. What that means is you need to be quiet so we can hear the proceedings. You are entitled to be here. I'm glad that you're here to observe, but it's just to observe. There's no public comment tonight. There's no audience precipitation. I hope that you all find this interesting. If anyone is disruptive, I'm going to ask them to be quiet. If that doesn't work, I'm going to ask them to leave. I hope that doesn't come up, but that'll be our ground rules. What we're going to do today is read some material, put on some testimony. At the end, there will be a vote, and then we'll conclude. So that's the basic plan. Again, my name is Todd Smith. We're here with Chief Sims and his attorney, Doug Carter. I'd like to begin by having the board, this is your council here in Lexington, come to order. Mr. Mayor, if you would.
Okay, bring the termination hearing to order. Roll call.
Daniel King.
Here.
Chandra Carey. Here. Tom Hughes.
Here.
Mike Kramer. Here. John Gordon.
Here.
Thomas Rowland. Ben Hanson. Here. Ryan Waddell.
Here.
All present? Very good. Pursuant to Section 106.273 of the Revised Statutes of Missouri, we're here to hold a hearing on the termination of Troy Sims as the Lexington Police Chief for cause. The purpose of this hearing is to advise the employee of the allegations against him, to explain the evidence against him, and to provide him an opportunity to present disputed facts. These proceedings are being recorded. The statements can be used against you in a subsequent administrative licensure court proceeding. This meeting has been postponed twice. The last time at the attorney's request. We're here today to hopefully get this done. The procedure for this hearing is I'm going to begin by reading the statutorily required notice. It's about 3 paragraphs long. Just bear with me. City of Lexington revised notice of intent to terminate. Date 9/10/2024. Chief Sims. Pursuant to Section 106.273 RSMO, the City of Lexington does hereby provide you with formal notice of its intention to terminate your employment as the city's chief of police for just cause. The city anticipates holding a recorded hearing on your termination on Wednesday, September 18th, 2024 at 6 p.m. at The Lex, located at 111 South 11th Street in Lexington, Missouri. The hearing will be open to the public and media. You are entitled to appear at that hearing, to present evidence and testimony, and to be assisted by counsel at your cost. If, at the end of the hearing, 2/3 or more of the council members vote in favor of termination, your employment will immediately end, and post will be notified accordingly. The Officer's Bill of Rights, Section 590-502 RSMO, does not apply to you as you're the highest-ranking officer in the agency. The specific grounds for just cause termination are that you have A, committed acts while engaged in the performance of your duties which constituted a disregard for the safety of the public. B, that you have misrepresented material facts for an improper person. C, that you have acted in a manner that is inconsistent with the interests of the City Council. And D, that you have acted in an insubordinate fashion toward the City Council, Mayor Pro Tem, and City Administrator. Any one of these grounds is sufficient for just cause to terminate your employment under the statute. The City alleges the following facts against you. 1, you were insubordinate on or about May 29, 2024, in which you profanely yelled at the Mayor Pro Tem your disagreement with a hiring decision that was not yours to make. 2, you were insubordinate with the members of council at a public meeting on or about June 11, 2024, in which you repeatedly screamed your disagreement with a hiring decision that was not yours to make. 3rd, after a public meeting on or about June 11, 2024, you discussed the substance of a closed executive session with employees not entitled to that information, which was inconsistent with the interests of the City Council. 4, you were insubordinate and misrepresented material facts on or about June 13, 2024 by threatening the Mayor Pro Tem and City Administrator with criminal charges for obstructing justice when you were instructed not to interfere with the Police Personnel Board's review of an employee candidate. 5, you were insubordinate in returning a police officer to his former elevated rank and position, having been specifically instructed not to do so. 6, you disregarded public safety by not placing an officer accused of a violent crime on administrative leave, pending the outcome of an investigation into that officer's conduct. 7, you pursued a shooting range for the police department without the proper authority or permission from the City Council and presented a proposal to the county for that purpose, again, without proper authority or permission, which was inconsistent with the interests of the City Council. 8, you misrepresented material facts by claiming to have authority and permission to pursue a shooting range when you clearly knew that you did not have proper authority or permission to enter into an agreement on behalf of the city or to formally speak on the city's behalf. 9, you were insubordinate in allowing employees to interact and drive with their spouses on duty in patrol vehicles when you had been specifically instructed not to allow such conduct, which constitutes a disregard for public safety. You have the option to voluntarily resign your employment before the hearing. If you decide to resign, please write a written and signed letter of resignation to the city administrator prior to the hearing. If you decide to retain legal counsel, please provide this notice to that attorney. If you have questions about this, you may contact Todd Smith, the city's attorney for this matter, in writing via email at tsmith@librarymunicipal.com. Respectfully submitted, Shawana Funderbuck, City Administrator. What I'm going to do now is present some testimony. They will be under oath. After I'm done, Mr. Carter, Mr. Sims' attorney, will have the ability to make his presentation. Carla, if you would not mind to swear in Sean.
Excuse me, I have a preliminary statement.
Oh, please, go ahead, counsel.
The current junior senator representing this great state in the United States Senate is a Republican. He is from St. Louis County. His name is Eric Schmitt. As many of you may know, before Senator Schmitt became United States Senator Schmitt, he was our Attorney General, and before that, he had a number of very distinguished years serving in the Senate at the state level in Jefferson City. In 2013, while in the Missouri State Senate, Senator Schmitt introduced and co-sponsored and then shepherded through to completion the statute that Todd just referenced that brings us here today. And as that became the law of this state, Senator Schmitt made the following statement, and I quote, "Ensuring a level of independence for police chiefs is important. You do not want to see the chief law enforcement official, probably the head of the largest department for some municipalities, caught up in the middle of political spats. To make sure that police chiefs such as Troy Sims do not get caught up in the middle of a political spat and have her or his job on the line, the legislation that Todd referenced, which brings us here today, which we are duty bound to follow, has procedures in it as well as substantive law. Let me tell you what I mean by that. It not only has those provisions that Todd wrote, which I'm going to go over here in just a moment in a little more detail, but it also has requirements procedurally that must be followed before any action can be taken by an elected body such as this council assembled here tonight. What I'm going to do is go through those charges and share with you why, from the standpoint of satisfying the notice requirements of the statute, it is not met, it is not satisfied, and for that reason, anything that the council does based on this particular notice would be subject to subsequent legal challenge, which I would respectfully submit has merit for the reasons I'm going to talk about now, and about which I think we should each be aware. The revised notice references 4 separate sections of the statute that define just cause, having stated that a chief of police shall be subject to removal from office or employment by the appointing authority or governing body, that's y'all, of the political subdivision employing the chief if the governing body by a 2/3 majority vote finds just cause for removing the chief. And the statute then defines what just cause is. There are 4 sections of the just cause definition that have been read now by Todd and which are issue. But all of the subparts of those sections, which are also requirements, were not read. So I want to go over them now. First, subsection B of the statute, and I distribute it in front of you all so you could follow in the governing body here. Just cause exists when a chief B has committed any act while engaged in the performance of his or her duties that constitutes a reckless disregard for the safety of the public or another law enforcement officer. Subsection C has caused a material fact to be misrepresented, and then these words follow, for any improper or unlawful purpose. D, acts in a manner for the sole purpose of furthering his or her self-interest, or in a manner inconsistent with the interests of the public or the chief's governing body. F, has been deemed insubordinate, we'll talk more about that in a second, or found to be in violation of a written established policy, unless such claimed insubordination or violation of a written established policy was a violation of any federal or state law or local ordinance. Now those last words are a little bit gummy, but what it really means, and I think Todd would agree with this, you can't be insubordinate for failing to follow an order if the order itself isn't lawful. And we'll talk more about that in a second. But the statute does not end there. Before we get to a vote that could be sustained upon review by a court, the procedural requirements of the statute must also be met. The relevant procedural statutes, which we've handed out in front of you in our Exhibit 3, it's marked, says removal of a chief law enforcement officer, and then it says a chief shall be subject to removal from office or employment by the appointing authority of the governing body of the political subdivision, employing the chief if, and I skip down to highlighted subsection 2, the chief has been given written notice as to the governing body's intent to remove him or her. Key words now, folks. Such notice shall include charges specifying just cause for which removal is sought, and a statement of facts, not conclusions, not generalities, a statement of facts that are alleged to constitute just cause for the chief's removal. And I added in what I just handed you here preliminarily the Holdeman case decided last year by the Missouri Court of Appeals for the Western District, and that's the appellate court that has jurisdiction over this side of the state. And the Holdeman court held that not only must you satisfy, this is a police chief from Sturgeon, Missouri, not only must you satisfy those substantive requirements, but you also, that are set forth in the police chief statute, which Todd quoted. But what he did not quote was the holding of Holdeman, which is you also have to satisfy the requirements of the Missouri State Administrative Procedure Act for what is called a contested case. And that statute reemphasizes that you cannot have conclusory statements, of merely a statement of the charges phrased in the language of a statute or rule. The problems with this notice, folks, are as follows. The first charge says that you were insubordinate on or about May 9, in which you profanely yelled at Mayor Pro Tem your disagreement with a hiring decision that was not yours to make. Insubordination, as used in the statute, as found in any dictionary, as used in the English language, requires, by definition, disobedience by the police chief of a duly issued lawful order. You're insubordinate because you do not follow an order issued by one in authority. Now, if you look at this charge number 1, there is no disclosure of the substance of any such order. There is no disclosure of who gave this alleged order, nor is there any detail with respect to when and how the order was allegedly given. Those are omissions, folks, which taint any decision you could make based on this notice tonight as being subject to being withheld upon further scrutiny by a court. Basic concepts of due process require in a charging document that greater specificity in those regards are present, which is absent here. The second charge, you were insubordinate, again that word, with members of the council at a public meeting on or about June 11, 2024, in which you repeatedly screamed your disagreement with a hiring decision that was not yours to make. Again, insubordinance required disobedience of a duly issued lawful order. There is no order referenced here as to which insubordination occurred. There is no detail as to who gave it, when, where, and how. As for charge 3, it states, at the public meeting on or about June 11, 2024, you discussed the substance of a closed executive session with employees not entitled to that information, which was inconsistent with the interests of the council. Charge 3 does not state what Chief Sims allegedly said, to whom he allegedly made these statements. We are just shooting in the dark. Nor does charge 3 state when, after the date of June 11, 2024, the statements allegedly were made. These are deficiencies in the notice which make it insufficient procedurally under both statutes. Charge number 4. Excuse me, guys, I'm gonna wet my whistle. I'm getting dry. Can I put this here? Charge number 4 states you were insubordinate and misrepresented material facts on or about June 13, 2024, by threatening the mayor pro tem and city administrator with criminal charges for obstructing justice when you were instructed not to interfere with the police personnel board's review of an employee candidate. Now here, we do at least have an order that's included, which illustrates what is required for insubordination. But insubordination requires disobedience not just of an order, but of a duly issued lawful order. Here, there is no disclosure of who gave the alleged order, nor when that order allegedly was given. Those are key facts with respect to whether the order is one that must be followed because it is lawful. In addition, that charge 4 references misrepresentation. It does not specify, though, what the allegedly untruthful statements were, nor does it specify any allegedly improper or unlawful purpose. It doesn't even touch that. And as you remember when I read the standard under the statute, it isn't just that you have misrepresented some material fact, it must be tied to some improper or unlawful purpose, and that has to be spelled out exactly what the theory or the claim is that's being made in order for a notice to pass muster under the due process procedures that are in place. Charge number 5 says that you were insubordinate in returning a police officer to his former elevated rank and position, having been specifically instructed not to do so. Again, insubordination requires disobedience not just of an order, but of a duly issued lawful order. And in this notice, there is no disclosure of the substance of the order, who gave it, or when the order allegedly was given. Key facts which must be included to satisfy the procedural aspects of the statute before you even get to the substantive claims. Charge 6 states you disregarded public safety by not placing an officer accused of a violent crime on administrative leave, pending the outcome of an investigation into the officer's conduct. Charge 6 does not state who the officer allegedly was. I might guess, but that's not the standard. It does not specify what the allegedly violent crime was. Key also, and more important perhaps, is it does not state who was allegedly investigating the officer's conduct, what information Chief Sims had on or about a particular date relative to the investigation, from which information Chief Sims should then allegedly have taken some action other than what he in fact did. It is completely bare of facts necessary for any insubordination claim in those regards. Charge 7 states you pursued a shooting range for the police department without the proper authority or permission from the city council and presented a proposal to the county for that purpose, again without proper authority or permission, which is inconsistent with the interests of the city council. Charge 7 does not state when and how the shooting range and the related proposal purportedly were pursued or proposed, does not identify an ordinance, a statute, or policy that prohibited the alleged actions or that required the alleged permission. It is fatally defective on those grounds alone. Charge 8 states, you misrepresented material facts by claiming to have authority and permission to pursue a shooting range when you clearly knew that you did not have proper authority or permission to enter into agreements on behalf of the city or to formally speak on the city's behalf. Charge 8 does not identify and specify when the alleged claim by Chief Smith was made or to whom, claim of authority, does not allege when or to whom, does not identify an ordinance, a statute, or a policy which prohibited the alleged actions or that required the alleged permission. Finally, with respect to Charge 9, Charge 9 states that you were insubordinate in allowing employees to interact and drive with their spouses on duty in patrol vehicles when you had been specifically instructed not to allow such conduct which constitutes a disregard for public safety. Charge 9 does not disclose who gave this alleged instruction or order, whether it was oral in writing and when. It does not identify any statute, ordinance, rule, or regulation that the chief's alleged actions violated, which identification is necessary to evaluate whether the alleged order was both lawful and itself justified. All requirements procedurally to be in there and then proven based on what is stated in the appropriate notice. Nor does Charge 9 disclose which employees and spouses were allegedly involved and when the alleged spouses were supposedly in these patrol vehicles. It is just a very bare conclusory statement. Now, again, I gave you the Halderman case because I wanted to share with you, and we highlighted, and I gave you the judgment as well that was entered. I wanted to highlight what the consequences of not following these rules are. And I want to explain now why I'm making this detailed objection. The Administrative Procedure Act says that reasonable opportunity, and this governs, shall be given for the preparation and presentation of evidence bearing on any issue raised or decided or relief sought or granted. It goes on to say that when issues are tried without objection or by consent, such issues shall be deemed to have been properly before the agency. Any formality of procedure may be waived by mutual consent. We do not consent. This is not a proper notice, and anything further that happens, if you decide to go ahead and hear your evidence or whatnot, I will be asking questions, but make it clear on this record, please, that we do not waive the objections that I've raised, and we do not consent to a hearing procedure to continue based on this defective notice.
Counsel, pardon my interruption. You would agree you did consent to having the revised notice in less than 10 business days?
We're not objecting. You didn't hear me talk about 10 business days. As I shared with you the very first meeting, this is a defective notice because it's too vague. As I shared it with you in subsequent conversations, I understood that you were considering whether to revise it. You did not. Here we are.
I'm asking about the date.
I have no objection.
To the 10 days.
I put that in writing to you.
Very good. Please continue.
I'm about done. But let me share this. Should this hearing proceed on the basis of this defective charge, because we do not waive those notice requirements, the hearing, whatever transpires tonight without mutual consent, means that under principles of due process and complying with the statute, we're just not there. We cannot reasonably be expected to defend against such fact-starved, conclusory charges. So I share with you all, sincerely, as good stewards of the taxpayers' dollars, we don't want to be in a situation. There was almost $800,000 in that Halderman case. Most of that was attorney fees. I can stand to benefit tonight if you vote against my client. But this city will not, its insurance carrier will not, its future rates will not, perhaps its insurability with anything but mob could be on the line if these continue. As good stewards of the taxpayers' dollars, and as required by the Missouri governing legislation and law, the hearing cannot continue absent a properly drafted, reasonably detailed statement of facts, not conclusions, but facts that allegedly constitute just cause for Chief Sims' termination as an employee of the City of Lexington, Missouri. Therefore, as I am empowered to do, having entered my appearance in this proceeding on behalf of Chief Sims, I can make motions. I move respectfully that these charges, as presently drafted and presented, be summarily dismissed, this hearing therefore adjourned, and on the ground that the notice requirements set forth in section 106.273 revised statutes of Missouri, otherwise known as the Missouri Police Chief Statute, and in section 536.063 of the revised statutes of Missouri, otherwise known as the Missouri Administrative Procedure Act, have not been duly satisfied and met.
With that, my response to my clients, these legal arguments are interesting, but I believe we shall proceed. With that said, Carla, I would like you to swear in Shauna, please.
Do you promise to tell the truth and nothing but the truth?
I do.
Can you use the microphone?
I do.
Can you all hear okay? Very good. Ma'am, please state your name.
Shauna Funderburk,
So you're under oath. I want to ask you some questions. What is your position in the City of Lexington?
City Administrator.
Very good. Are you familiar with the notice of termination intent?
Yes, I am.
I would like to ask you some questions. The first allegation regards an event that occurred on May 29th, 2024. Were you present at that event?
Yes. Oh, no. I started June 11th.
June 11th. On the second one, were you present on June 11th, 2024?
I was.
The allegation asserts that Chief Sims repeatedly screamed disagreement with a hiring decision that was not his to make. Did you witness that event?
I did.
Did you feel that his comments were insubordinate?
I did.
You do feel they're insubordinate?
I do, yes.
On that same public, I will skip that one to number 4. On June 13th, were you told by Chief Sims that you were obstructing justice?
I was.
Did he tell you that in regards to his interfering with the police personnel board?
Yes.
Did you ever threaten anyone with violence, force, or physical interference, which
No.
is what the obstruction statute 576.030 states?
No.
At no time did you threaten a violent act.
Nope.
You directed him as an employee of the city not to interfere with the personnel board's actions.
Yes.
Was his... You're fine, man. He was unhappy with their conclusion,
Yes.
and in response to that, as a chief of police, he says you're obstructing justice, right?
Yes.
Are you aware about an employee named Officer Cobb?
Yes.
Did that officer resign from the Lexington Police Department?
That's my understanding. It was before I worked here.
When he returned, were there instructions about the manner of his continued service?
Yes. There were very clear instructions from the police personnel board as well as the mayor and city council that Officer Cobb was to be returned to the city of Lexington if he was rehired at an entry rank and to no longer be an FTO and to undergo other training and to not be reinstated at his corporal rank.
So he quit as a corporal. When he comes back, he's entry level, no rank.
Correct.
When he subsequently returned, did you learn that he was officing in the corporal's office?
I did.
Did you learn that he was wearing the corporal's uniform?
Yes, that's what I was told.
Objection, move to strike what she was told. That's inadmissible hearsay.
Thank you for the comment, counsel. You in regard to a police officer accused of a violent crime, was it your view that that officer should be placed on administrative leave?
Yes.
Did Officer Sims disagree with that?
Yes.
Was it your opinion that that officer posed a threat?
Yes.
Are you aware of the situation where Officer Sims pursued a shooting range?
Yes.
Did you authorize, to your knowledge, did the city council ever authorize him to get a shooting range?
No.
Is he authorized to enter into contracts on behalf of the city?
No, he's not.
Is he authorized to negotiate on behalf of the city?
No, he's not.
Does the city want a shooting range?
No.
Why not?
It's a huge liability, and the location that was selected could have had potential environmental pollution issues.
And that's from the ammunition and casing.
Correct.
Is it your understanding that Officer Sims implied that he was authorized and entitled to enter into those negotiations?
Yes.
Was there any question that he's not the city's spokesperson?
No.
Are you familiar with the Missouri statute of frauds?
Vaguely.
Can a city buy real estate in any manner other than by a vote of a council in written contract?
No.
Are you aware that Chief Sims allowed police officers on duty to have their spouses in the car?
Yes.
That includes spouses that are policemen, in fairness,
Yes.
but also spouses that are not.
Yes.
Do you deem that a safe and reasonable practice?
No.
And why not?
It can cause different judgment than they may have if their spouse was not with them. Could change their decision-making on scene.
Do other city employees, are they allowed to bring their spouses to work?
Absolutely not.
Are they allowed to be out of supervision for lengthy periods of time?
Nope.
Are police officers theoretically in a position to need to respond to an emergency at a moment's notice?
Yes.
Are police officers in a position where they may need to use lethal force in a moment's notice?
Yes.
Would an innocent bystander in the car obstruct their ability to effectively perform those duties?
Yes.
All right. Carla, I'd like you to swear in Mayor Pardon.
Hold on, I have some questions for you.
I thought you wanted to wait until the end, but if you want to cross now, you may.
First, I have a question. Carla, do you administer the oath?
For the officer.
Yeah, are you a current Missouri notary public?
Yes.
Okay. I didn't see that listed on the Secretary of State's website. And ma'am, you took your job when?
June 11th.
Of this year,
Yes.
correct? So you don't have any firsthand knowledge of anything that happened before June 11, is that correct?
I do not.
And many of the things you just talked about, you don't have firsthand knowledge about as well, correct?
The majority of the things have happened since I've been here.
Well, I'm talking about firsthand knowledge, not stuff you've been told.
I have people tell me information for my position.
Yes, but in terms of what you yourself observed.
I did not observe. Which points are you?
Well, let's go through them. And I mean, I think what you said is in some ways speaks for itself already. Hand out the book. The exhibit. I want to ask you about some documents and some city ordinances and some city policies. Did you, when you got here, try to get up to speed, reading all the ordinances, reading all the policies for the various departments, past minutes from council meetings, things like that?
Yes, I have read some, not all.
Council, I'm going to object for the record. Unless these ordinances are certified by the city, they're inadmissible.
Well, you can
My objection.
make that objection if you want.
I do have that objection. It's noted for the record. I take it they're not certified?
Right off the website, Council.
Thank you.
Hot off the press, so to speak.
Yes, sir.
Now, ma'am, if you turn to Exhibit 1, that's the charges, and if you look at charges 1 and 2, they begin with these words, do they not? You were insubordinate.
Yes.
Now, turn, if you will, to Exhibit 4 in the book.
Thank you, ma'am. Appreciate it.
You see a definition of insubordination there from the Collins Dictionary?
Mm-hmm.
Yes?
Yep.
And then a definition of being insubordinate, correct?
Yes.
And you would agree with me, to use the Collins definition, for example, that insubordination is refusing to obey orders from people in authority.
And I will
Is that
object.
reasonable?
Your question calls for a legal conclusion. This Cambridge dictionary has no legal authority. You may proceed.
I'm talking about just common everyday language, like we read in statutes, like we read in the newspaper, the word, like we read in notices, like did you write this notice I talked about at length a moment ago?
Our legal counsel wrote it.
Okay, but you read it, right? You saw the word insubordinate, right? And you would agree with me, would you not, that insubordination means refusing to obey orders from people in authority, correct?
That's one part of insubordination, yes.
Well, you say that's one part of it. Have you ever seen another definition of insubordination?
Yelling at your superiors is insubordination, that's common knowledge.
You think it's common knowledge that yelling at your superiors is insubordination. You understand insubordination is a word that's used in the statute.
I'll object again, counsel. You're implying that there is a legally defined term in insubordination, and this dictionary definition is not that. The witness has described your answer. Thank you.
Well, you've got Exhibit 2 in front of you there. Turn to that. That's the statute. And that's the sections of the statute that are cited as they're codified in your notice. Would you read out loud where it says that you can fire a police chief for raising her or his voice or using profanity? Read those words.
I think F could apply.
F
On
could
personnel
apply.
policy.
Read that out loud if you think that says that yelling or using profanity is insubordination.
Counsel,
or it's
she's
vi-
answered the question that she believes it does. She doesn't need to read it. Next.
What does it say? What words are you saying that mean no yelling and no profanity?
I'm advising you not to answer that question.
Are you going to follow this advice and not give me a chance to ask you questions on this particular matter?
I'm happy to have a further question, but she's not going to read that again.
Are you going to follow this advice and not allow me further inquiry on why you think this statute says that a police chief, if he uses profanity or yells to a mayor or someone else, that's, assuming that occurred, that's grounds under the statute?
Counsel, respectfully, you're misquoting her testimony. She did not say this statute says that. She says her understanding of insubordination can be accomplished by yelling at your superior.
Well, counsel, if you want to
point you
take
made.
the stand and take an oath, I'll be glad to ask you some questions too.
Sir, we're not in court. You've made the point.
Are you going to follow this advice not to answer, even though you've been sworn to answer questions in this proceeding?
Also not true. She's been sworn to tell the truth, which she has.
Are you going to answer my question?
I follow legal advice.
Well, okay, then let's talk about this alleged disagreement with a hiring decision that's referenced in charges 1 and 2, okay? Now, read aloud where it says in there who the officer is in the charge itself. That's Exhibit 1.
There's not a name listed.
Well, are we, I mean, am I supposed to guess, or is there some other document that I've been furnished that would tell me who it is?
I assume you were able to do discovery before the hearing.
Well, I would if it was a lawsuit. I hope it doesn't get that far, and that's one reason I took the council through the standards and the procedures in hopes that we don't get that far, okay? To where there's a lawsuit over the termination rather than the discipline that's already been given, which we'll talk about here in a minute, okay? But, so you say you assume we got discovery. What do you base that assumption on?
It was my understanding you could have contact with our attorney for any questions you had.
Okay. And you're saying that to fill in the gaps, I needed to, rather than have it in writing, call him and ask him who the officer is?
You had that option.
Well,
I don't dictate your procedures. So.
Well, do you yourself know who this officer is?
I sure do.
Oh, okay, well, why don't you tell us so we know?
It's David Cobb.
David Cobb. Did you suggest that maybe a little more information on what this charge is should have been included in this charges 1 and 2 when you read it?
I will object to that. This witness is not in a position to speak about what the city did. The city acts through votes. The city voted unanimously to send out this intent. The city administrator cannot be impeached based on the acts of the city.
I'm just asking you whether historically you suggested, hey, maybe we ought to give them a little more information. I mean, you've been in city government for a while, haven't you? Yes?
Yes, over 25 years.
Okay, and you've worked as an administrative assistant in Liberty, for example, right?
I was not an administrative assistant. I was a chief strategic operations officer.
Okay, I won't repeat. Okay, Chief Strategic Operations Officer. So you learned about city procedures, you learned something about statutes, you learned we're in closed sessions, you're in open sessions, right? So were you in some way told not to suggest that, hey, maybe we need to beef this notification up so the procedural objection I made a moment ago wouldn't create a cancer, just kill it right out of the get-go if it gets up on appeal?
We
And I
followed
will
our
object-
attorney's advice.
Wait, hold on. I'm going to object to any question that calls for her to describe attorney-client privilege communication or advice.
Well, does that mean you're answering my question or not?
I'm telling my client not to answer what you and I talked about.
Okay. Well, then let's talk about this. These concerns, the subject of the alleged, how was it put, the disagreement with the hiring decision, quote unquote. This disagreement was a subject that was discussed with Chief Sims more than once, was it not?
That's my understanding.
Well, it's also your personal knowledge because you were in at least one such meeting, were you not?
On June 11th, yes.
You were in a June 11 meeting, and it was also discussed, as you understand it, on May 29 as well as referenced, correct?
That's what I was told, yeah. I did not work here then.
And it was also the subject, this disagreement, was also the subject of a coaching session, so-called quote-unquote coaching session, that you and Mayor Harden conducted with Chief Sims on June 24, 2024, was it not, ma'am?
Yes.
After the coaching session, where these same subjects were discussed, there were two, what the mayor referred to, Mayor Pro Tem referred to as write-ups placed by yourself, I presume, correct me if I'm wrong, in Chief Sims' personnel file.
They were provided by the mayor as he is his direct supervisor.
I'm asking whether there were two write-ups that either the mayor himself or you put in the employment file after that meeting on June, the coaching session meeting on June 24 of 2024.
That's my understanding.
Okay. Now, just so we understand what these write-ups are, in this coaching session, the mayor referenced, did he not, the employee handbook and specifically chapter 16. Do you recall that?
Yes.
And is that part of when you were getting up to speed to do your current job of the materials that you yourself reviewed so you would know what is in the employee handbook? Is that a yes?
I've reviewed it. I have not memorized it. I've been here 3 months.
Okay. Well, first off, if you turn to Exhibit 5 in that book, do you recognize that as that chapter 16 that you've reviewed but not memorized?
It looks familiar. I haven't memorized it.
And it talks about on pages 2 and 3, doesn't it, progressive discipline. Yes?
Yes.
And it has 4 levels of progressive discipline. The first being a verbal warning, correct?
Council, I will object here on 2 grounds. In the first place, I will reiterate my objection. These ordinances are not certified and not admissible. Secondly, city ordinances are not binding on the city council. They have no legal effect. They are not a collateral estoppel. They don't define or confine their actions. Please continue.
Council, you just said city ordinances don't apply to the city council?
I did.
So you're saying if the mayor goes speeding 70 miles an hour right down Main Street out here, that he can't be given a city ordinance ticket?
No, sir. I'm saying if you have an ordinance that says we will discipline employees in a particular fashion, It does not mean they cannot the next day elect to do something differently.
Well, counsel, you weren't at that meeting, that coaching session meeting, were you?
No, sir.
But the witness just shared that at the beginning of that meeting, the mayor himself referenced this document, Chapter 16 of the Employee Handbook.
No
Did you
problem
not
with
hear
that.
that?
No problem with that.
All right.
I'm just saying, if you're implying that there is a legal basis for impeachment because this ordinance was not followed meticulously, that is not the law in Missouri as it pertains to a municipal corporation.
I'm just talking about the discipline.
Sure.
I'm just talking about the discipline that he has already gotten. We're going to get to the discipline that someone is proposing here more directly in a minute, but it'll relate. And at that coaching session, he was given the second level of a 4-level discipline process, was he not? The first level is verbal warning. Second level, if you look at pages 2 and 3 there, second level is a written warning. Third is suspension. Fourth is termination, correct?
Mm-hmm.
Yes? Is that a yes?
That's what it says, yep.
Now, on what you gave, the mayor gave, and you, with your acquiescence, on the 24th of June of this year, was the second level of discipline for these subjects, this disagreement, what he had been saying, Troy Sims. You gave him the second level of discipline, the written warning that went in his file, correct?
It was a coaching session, yes.
And you were just handed a note by the mayor. Would you share what that says, please?
It is a copy of the coaching session.
It is a copy of the coaching session.
Mm-hmm.
Okay. Do you know what the it is?
Sorry, what?
The it.
I'm sorry?
You said it is a copy of the coaching session. Is that what you said? Okay.
Piece of paper.
Well, let's mark it.
Counsel, this is not a trial. We don't need to mark evidence. And besides, I would submit that that's inadmissible.
Well, I want to see it.
I'm sure you do.
This is a document for what the coaching session did. Is that your understanding?
Yes.
Is there a reason this wasn't included as part of the charges here today?
We included what our legal counsel asked us to.
Well, look at Exhibit 5, which is the handbook policies on discipline. And on page 2, do you see a section that says, that's 16.03? I'm going to need some more light over here at some point, guys. I need to try to figure out a way to do that. You see 16.3?
Mm-hmm.
Could you read that aloud, section 1 and 2 for us, please?
Yes. Only the city council has the authority to terminate an employee. An employee may be suspended by the city administrator pending a decision by the city council with or without pay. 2, personnel actions less than termination may be taken by the supervisor with the approval of the city administrator.
And so when we're talking about the discipline that y'all issued on the 24th, it's already in the file for this employee. You're talking about doing it with the supervisor approval, and then you implemented it, correct?
Yeah.
Yes?
Yes.
As stated in the policy 1603, right?
Yes.
Okay. Now, let's talk a little more about these concerns that Chief Sims was voicing that led up to this coaching session and formal discipline being taken against him by the city of Lexington. Do you recall, ma'am, that the Chief Sims accused the Mayor Pro Tem of serious mismanagement with respect to the Lexington Police Department?
Counsel, I will object here. You need to have your client provide that testimony here. Your recitation, I'm sure, is accurate, but I don't think it's appropriate to ask this witness to answer what you say your client said elsewhere.
I'll be real clear with my question. Do you, ma'am, yourself recall that Chief Sims accused the Mayor Pro Tem of serious mismanagement with respect to the Lexington Police
Hold on a second.
Department?
No.
It's a medical problem.
Who is it? I don't know. No, we're going to pause for it. There's police paramedics there.
That's up to you. You need to.
Counsel. Looks like it's running past out of this.
Good thing my paramedics there.
Yeah. Don't just stay here if you can. Well, I just wow. No, you're fine. We can recess if necessary, but I would really prefer not. The camera's still rolling, I think. Counsel, we had an issue in the audience. We think it's a medical problem. We're taking a pause to figure that out. Folks, we're going to try and get back starting again. Obviously, these things happen. Somebody had a medical issue. My thanks to the folks in the audience that helped take care of that. I gather they've cleared the scene. I've talked to Mr. Carter. We're going to go ahead and get back up and started again. Counsel, I think it's your examination. Thank you all very much for your understanding and patience.
Can you turn the mics back on?
Counsel, before you...
Yep.
We'll get you. Try that.
Testing.
Yeah.
Counsel, before you walk back from the mic, would you please put on the record what happened just now, not with respect to the incident in the audience, but with respect to the entire council being behind closed doors here?
Sure. I had the council go behind the stage, and I gave them legal advice about what had just happened, and we came back out.
And was there a motion made for an executive session before that occurred?
No.
We would object on that ground.
I'm sorry. It's not a public hearing.
In any event, Madam Public Administrator,
City Administrator.
do you recall that in this coaching session we were discussing, where these allegations and concerns that relate to this so-called disagreement on an employment decision were discussed, do you recall that Chief Sims accused the Mayor Pro Tem of serious mismanagement with respect to the Lexington Police Department?
I do not recall that.
Do you recall that Chief Sims stated that the Mayor Pro Tem had ruined the police department in a month?
Yes, he did say that.
And do you recall Chief Sims saying that in his judgment that the situation presented a substantial danger, a specific danger to public safety in this community?
I don't recall that. No, I don't remember that.
Well, what do you remember in that regard?
I remember him accusing the mayor of ruining the police department in a month.
And you don't recall any discussion that left people that were shorthanded, that Chief Sims had been on a 20-hour shift already, that they're having coverage to keep the streets safe in the community, to have coverage like you need. You don't recall any of that?
And I will object. This testimony from counsel implies that those things were said. He needs to have the witness present that testimony. Please proceed.
Do you remember my question?
Mm-hmm.
Do you remember Chief Sims saying words to the effect that what his concerns were threatening the safety of the community?
He said that, but there was already a shortage of personnel. I mean,
well, let me see.
Long before that.
I'm sorry, I'm not going to cut you off. Did you finish? Mm-hmm. Yes? Well, I mean, and for that matter, if there's a shortage of personnel before that, then having situations where officers are distracted, wanting to resign, have bad morale, would you characterize those as good or bad things for the safety in this community?
And I will object. This is far afield of the allegation. You should confine your questions to whether or not the chief was insubordinate in his disagreement on this action. Her opinions about the safety of the community are not relevant to the factual question before this body.
Do you recall Chief Sims saying words to the effect that the situation that was created, morale, shortages, that it was getting worse, it had been ruined by this mayor, and that threatened public safety in this community? It's a simple question.
He alleged that. That was his opinion.
Well, let me see if I can fill in some of the gaps in terms of part of what was said. Would you publish Exhibit 6, please?
Was the morning after we didn't hire Cobb back, and
Counsel, can you pause that for a second? What is the source of this recording?
The recording is of that meeting, and I would like it to be played. We'll talk about it here in a second.
You'll tell me where you got it.
where I got it.
Yes, sir. Who recorded this conversation?
The chief did.
Thank you.
Go ahead.
Quite
Start at the beginning.
animated.
Roll it back to the beginning.
That was the morning after we didn't hire cop back. And, you know, you were quite vocal and animated and, you know, saying, you know, the councils were targeting you and sabotaging the police department. And I don't know why Greg Mitchell got blamed and everything, but you did. That's what I wrote up. You can look at that. And then there's this one here. That's all of that pertains to our employee handbook of chapter 16. Okay. And we got to get our communication going forward. I don't know where the disconnect is.
Well, in a month's time, you can absolutely ruin this department. One more time. I've never seen a department this bad. It's morale is horrible. Guys are looking for other jobs, and I don't feel like anybody really cares, other than me. I'm going on 20 hours right now because I got nobody. So.
Did we have coverage this weekend or?
Yeah, we had one guy on the whole time.
Mm-hmm.
It's not good. It's not safe. It's not.
Well, it's not sustainable. Yeah, that's
Very bad.
for
It's
sure.
very bad. And somebody gets hurt, and now we're talking about a rip lawsuit.
Mm-hmm. Yeah.
So, like I said, nobody really cares. So,
What do you mean nobody really cares?
I don't think anybody cares. Nobody's taking me serious. I've trying to address these issues, and nobody will listen to me. So.
Okay, well, there are issues that your
Is that going in a personnel file?
Yes, it is.
Okay. Good.
And is it
One
you
second,
that,
counsel. I'm going to object for the record. There's no foundation about when this recording was made, who's there. If it's accurate, it wouldn't be admissible in any court in this state. I further suggest the dictation, here again, it's not a certified transcript. Finally, this is a method to get your client's testimony in without subjecting him to cross-examination. I object to all of it. Its content, its introduction, and its use in a further proceeding. Thank you.
are you done?
I am. For the moment.
Okay. Well, you recognized voices on that, did you not, ma'am?
Mm-hmm.
Whose voices did you recognize?
The mayor, Pro Tem Hardin, and Chief Sims.
And you remember those things being said in the coaching session, do you not, ma'am?
Yep.
Yes?
Yes.
Okay. Now, let's draw some more on your experience as a person working for city government, okay? You've learned, have you not, over the years, that statutes that apply to municipalities must be followed, correct?
Mm-hmm.
Yes?
Yes.
And you've also learned about the Missouri State Whistleblower Statute, have you not?
I've never read it, but I've heard about it.
Well, let's see if we can improve your knowledge on that by turning, if you would please, to Exhibit 7 in the book.
Counsel, I will object to this line of testimony. This is a fact witness. She's not an attorney. She said she doesn't know about the law. This is far afield from the question before this group. Did Chief Sims engage in the conduct we've alleged?
Now, Counsel, I'm going to share with you that this city council has a right, each individual member, to know what laws may be violated if they take further disciplinary action on top of what's already been violated.
And you're not their lawyer. I am. I'm making my objection.
That's true. I have represented and had the pleasure of representing many cities, from Kansas City on down to Greenwood and all sorts of stuff. But you're right, Counsel. Tonight I'm on the other side.
Yes, sir.
Now, the whistleblower statute. You're aware that statute exists, ma'am?
I've heard about it, yeah.
And if you read what we've highlighted there, it says no supervisor or appointing authority of any public employer shall. You understand you're a public employer, right? Yes?
Yes.
And you understand that this is a supervising or appointing authority that's assembled here tonight, correct?
Yes.
No supervisor or appointing authority of any public employer shall prohibit a public employee. You understand Chief Sims is a public employee, correct?
Yes.
Prohibit a public employee from or take any disciplinary action whatsoever against a public employee, continuing on, for the disclosure of information which the employee reasonably believes evidences, and then you go down to B. You see mismanagement, you see abuse of authority, and you see a substantial and specific danger to public health or safety. Did I read those phrases correctly?
Yes.
Now, Chief Sims, before he got disciplined before, had indeed disclosed information about a threat to public safety, about mismanagement, and potentially an abuse of authority, as you understood it. Did you not, ma'am?
That was his opinion.
He disclosed it. And you understand, do you not, that if we go to on in the statute that says that if indeed there is disciplinary action taken after an employee has made such a disclosure that relates to it, that there can be a civil action brought against the public employer. That means the city. I'm reading from subsection 1 there. Do you see it? For damages within a year after the alleged violation. Do you see that?
Mm-hmm.
Yes?
On the second page?
Yeah.
Which one is it?
Subsection 1.
Of Exhibit 7?
I'm sorry, my bad on that one. Turn to 8.
Okay.
My bad. Turn to tab 8. There can be a lawsuit, right? For damages.
She's not going to answer, give you a legal opinion. You've asked her if you've read the statute correctly. She said yes. I'm directing you not to give a legal opinion on this matter.
Well, I want your opinion on this matter, ma'am, because you have certain duties to this city, do you not?
And again, counsel, she does not speak for the city. The city speaks exclusively through resolutions and ordinances. You are attempting to impute her personal lay opinion about a statute that's not raised here as an attributable fact to this city. That's crazy. You asked the janitor, would you please give me a legal opinion on this contract? That is not admissible. That is not proper. She can't be asked to be impeached about her personal view on this.
Ma'am, you have certain responsibilities in terms of talking to these council members and performing other duties, do you not?
I do.
And as a general proposition, it's good for you to know what the law is as far as it relates to your job, right? Mm-hmm. Yes?
Yes.
And it's good for you to know if there's going to be something the city does that could cause liability, that you ought to make that known, right? Mm-hmm. Yes?
Yes.
In fact, we heard you do that in some of what Mr. Smith here read earlier, where you're talking about the spouses in the cars. That's a liability, as you put it, correct?
Correct.
And in this instance, you're aware, are you not, that if there's any disciplinary action taken that's in response to that sort of a complaint, that sort of a disclosure, like we just heard Chief Sims do, and then you discipline them, that can be a problem for the city. You at least know that much, do you not?
Respectfully, counsel, you've asked and answered this multiple times. You are asking her to accept your definition of disclosure, and you're asking her to concede there's liability. She's not an attorney. She can't bind the city. I'm directing you not to answer that.
And you're going to follow his direction and not say any more on that?
Yes.
Well, then let me ask you this. Would you at least agree with me, ma'am, that it is not a good idea for the mayor and city administrator to discipline a city employee such as Chief Sims in violation of the Missouri State Employee Whistleblower Statute that we just went over?
Asked and answered again.
You would agree it's not a good idea to discipline, correct? In violation of a statute, that statute.
And I'm directing you not to answer. This is a recitation, it's just changing the words around. You're asking her again to give a legal opinion that binds the city, which she cannot do and won't under my recommendation.
You want to answer my question, whether it's a bad idea for the state to violate the whistleblower statute by imposing discipline? Just as
Counsel,
a
you
general
keep
proposition.
asking this over and over.
And all
She's not gonna
all she
answer.
has to do is give an answer, and I'm moving on.
And I've advised her not to. You should move on.
I take it you're going to continue to follow that advice.
Yes.
Yes? You got to say it out loud so it picks up
Yes.
a mic. All right. Well, then my other question, that was about discipline. Would you agree with me that it's an even worse idea for this city council to fire a city employee such as Chief Sims in violation of the Missouri State Employee Whistleblower Statute?
Counsel, clearly you're just rephrasing the same question again. I'm directing you not to answer.
And you're going to follow?
Yes.
Okie dokie. Well, let's look at charge 2 again. Now it references, does it not, a public council meeting? Yes?
Yes.
Now, public council meetings are recorded, just like this one is being right now, except in a different location, correct?
Yep.
And it is possible, therefore, to listen to historical recordings of council meetings on the Facebook page to hear what was said or conversely not said. Make sense?
Regular session, not executive session.
Well, this says public meeting, so we're talking about the public meeting in the charge, right?
Correct.
It doesn't say executive session, does it? It says public meeting. Yes? You got to say yes for the record. I mean, I know what it says, but I want to make sure you do.
It was a public meeting. It was noticed up as an executive session.
Well, it says the charge is a public meeting. There's nothing in there about executive session, nothing, is there?
Well, it was noticed up as a public meeting for that day.
I'm talking about notice up for this hearing. It references it as a public meeting, right? Not a closed session meeting. Are you with me?
You're talking about this hearing right now.
So I'm talking about the document you maybe wrote, and it says public meeting, does it not? Right there in charge 2. You want me to read it out loud myself?
I guess I'm confused.
Ma'am?
Is he talking about?
I can turn back and read it. Or is the answer yes, it's a public meeting? Those words are in there, right?
An executive session is noticed up to the public.
Wait, I'm talking about what we're here today for, okay?
Yeah, point number 2. Yep.
Point number 2 says, does it not, you were insubordinate with the members of council at public meeting on or about June 11, 2024. Did I read that right? Okay. Now, have you gone back and listened to the recording that's available on the website of that June 11 meeting?
Nope.
Well, I'm going to enter into this record what we're marking as Exhibit 9, get the envelope, and I'll share with you, I captured that entire public meeting, and I'm going to put it in this record now as our Exhibit 9. Now, it went on an hour. I'm not going to play it, but I'm going to ask you this question. You ready, ma'am? You ready? If I represented to you that if we played that whole public meeting recording, start to finish, from the pledge on through the adjournment, that Chief Sims doesn't utter a single word, whether it's yelled or not, would you accept that as true?
He did not yell during the regular session.
No. Okay. Let's go on to charge 3. Charge 3 states, after the public meeting on or about June 11, 2024, you discussed the substance of a closed executive session with employees not entitled to that information, which was inconsistent with the interests of the city council. Did I read that correctly, Ben?
Yes.
Now, did you yourself hear Chief Sims share anything that was said in that June 11 executive session with anybody that wasn't in there?
No.
Let's play a short clip, Exhibit 10. This is also from the coaching session.
This is the recording again?
Yeah.
Same objection as before.
when I was letting the police board out, so we could change people for the executive session, I was kind of in the doorway. I heard you tell your officers we will have to go back to the command post to talk. So, and anything, you know, when we're in executive session and you're with us, that has to stay here.
I didn't say anything.
Well, I don't know what, you know, going back to the command post and talk. So,
We were all on duty.
Now, Matt, you would agree with me, would you not, that a chief of police for a city like this one, when he's got officers on duty, he can go back to the command post and talk with them, right?
Sure.
You have no evidence whatsoever that this exhibit, charge 3, isn't made up out of total whole cloth, that has any substance, do you?
Counsel, we have not finished with our presentation of evidence.
Well, I'm asking this witness.
Very good.
Anything you know, even if it's been told to you, what do you know? What do you think you know? What do you want the governing body of your employer to know?
The mayor relayed that he heard what Troy said, which he just said in that meeting.
Well, what he said, yeah, was that, but there's nothing wrong with what Troy said, is there? Even in your judgment, right? That he's going to go back to the command post and talk with his troops. I mean, is that what, you think that frames up to discipline this with firing your chief because he said that? And somehow you're going to suggest that it's executive session? Do you have any information to support this?
Listen, this witness, again, does not speak for the board. This board unanimously approved this particular notice. She didn't draft it. Her opinion on it's immaterial.
And did that approval occur before I advised the board of Chief Sims' position on these procedural and substantive matters, or was it after?
They approved it weeks ago.
That's what I'm trying to get at here. Based now, weeks later, tell us why this charge is in here. Is it just what that your mayor heard your chief say? I'm going to go back and talk to my troops after a meeting when they were on duty, and for that you're going to fire the mayor as just cause under the statute? Is that what you're telling us, ma'am?
It was after the executive session.
Well, yeah, after, fine, thanks. But I'm saying after the executive session, he said, come back and we're going to talk to the troops. There's nothing wrong with that. That's what you base this on? Is there you signed this thing. Is there anything else you know of? Or is it just whole cloth?
It's what the mayor heard.
What we just heard.
After the executive session.
And you say that's just cause to fire chief. Is that where we're coming at? Is that what we're down to here, ma'am?
Hold on. I think you're harassing this witness. She's answered your question. Your point's well taken.
Well, okay.
Yes.
If my point's well taken, then I'll move on. If that point is well taken, I'll move to charge 4.
I appreciate it.
All right. Charge 4. June 13, 2024. It says you were insubordinate and misrepresented material facts on or about June 13, 2024 by threatening the mayor pro tem and city administrator with criminal charges for, quote, obstructing justice, close quote, when you were instructed not to interfere with the police personnel board's review of an employee candidate. Did I read that correct?
Yes.
Now, let's nail down exactly what order you're saying that constitutes this insubordination. What exactly was the chief told to do that made him insubordinate when he said things on June 13, 2024, referencing what you have quoted as obstructing justice?
So he decided to open a criminal investigation, which our attorney said had no grounds, it was not justified. He decided to open a
Is that a knowing waiver of attorney-client privilege on that issue, counsel?
No, it's not. She can't waive it because she's not the counsel and they've not passed a resolution to that effect.
Well, you better be objecting now just because when something like that gets said.
I will object. Thank you for the help.
Help any time I can, counsel.
Yes, sir. Not admissible in any court in this state.
What is the in order that wasn't followed? And when was it given by whom?
Again, I will object. That implies that your offered definition of insubordination can only relate to an order. We contest that definition. It's not controlling. It's not in the statute. With that being said, please answer if you can.
Okay. Said he was going to criminally investigate, or he was criminally investigating 2 fire department staff, saying they were slandering and libeling a former police officer that he wanted to have rehired. And based on our attorney's direction and the treatment of the police chief of those fire personnel when they had not committed a criminal act, therefore a criminal investigation was not warranted, he was told by the mayor to cease that criminal investigation of those employees. And he refused and said that if we asked him to stop his criminal investigation, we were then obstructing justice.
Okay. Well, let's go over what you just shared a little bit. You said that your sworn testimony is that in this June 13, 2024 meeting, that the police chief, Troy Sims, said that you said slandering and libeling with respect to an officer. Is that what we said? That's what he said?
Yes, he claimed that was
Slander.
that was justification for a criminal investigation of other employees.
And he used those words, slandering and libeling.
Yep.
That's your sworn testimony. Say yes.
Yes.
Okay. Well, what facts did he misrepresent? If that was the order, what were the facts?
The facts were they were not slandering and libeling a previous officer, and it was viewed that he did not have grounds to be investigating those employees.
Okay, let's do this. If you all would turn to tab 12 in our booklet we've shared with you. And just for ease of reference, we're going to play Exhibit 11. This is a recording of this meeting that we're talking about, ma'am.
And again, counsel, for the record.
Yeah, it was done by the chief.
It's a recording by the chief. No foundation, where it was taken, who's on the phone, or excuse me, on recording, when it was done. Absolutely hearsay, wouldn't be admissible in any court in this state.
Well,
thank you, ma'am.
I must respectfully disagree.
Yes, sir.
I'm Shauna Funderburg. I was formally with the other night. It's a big, nice to meet you. Nice to meet you.
All right, so what we want to talk to you about today is our conversation today. We need to stick with that. We need you and/or the officer, you will not be doing an investigation on that, okay?
No.
That's an order.
This is turning into a criminal investigation. It has turned into an investigation of a false affidavit. So there is a criminal investigation started, and we're going to continue with that. This is not a personnel investigation any longer. It's a criminal investigation. I cannot talk about it anymore.
I'm telling you need to step back. Okay?
You're ordering me, now you understand the obstruction of investigations, correct? Okay. This is a criminal investigation and it will not, until we're done. So, I don't know where it's going to go, don't have any idea, but you need to talk to the city attorney as well. Okay?
So you can turn this into a investigation.
Yeah.
I guess who's the defendant, I guess?
Well, it would be Erica, Caitlin, or Nathan. Right now.
Eric and Caitlin or Nathan are named in the investigation?
Yeah, one, oh, now, as far as the personnel issue, it kind of goes hand in hand and kind of mixed together.
The personal issue with
Comp.
comp.
Yeah.
So now we got a criminal issue with it. I will talk to our attorneys concerning that. And get their opinion on it.
I talked to him today, and he was gonna get with, Hunter was gonna get with Jeremy. He was gonna try to, and then get back to me Monday. So, that's course of action.
So you talked to Hunter?
Yeah, we had the municipal court today.
And you can't share any other information about how it came about, or?
Not at this time, I can't.
Okay. Either Jeremy or so, to get their advisement on it. So what triggered the criminal?
Well, that's my question, what triggered it?
Probably the last council meeting. I mean, there was some obvious things that weren't right and didn't sound right. And then after talking to it, he said, that was the funeral home.
Was that funeral, was that related to this case, or was it just?
Yeah, that's the April 19th.
Okay.
Yeah, that Cobb is supposed to be there.
Okay, well, I guess we'll get back with our attorney. See what they advise us to do.
I think they were going to call me and advise me on it. I haven't heard of a couple of other ones. As far as there's more interviews that need to be, so he was going to get back with me.
Well, that's a criminal issue, that's one thing.
Yep. It's two things. It's one thing that merged into another thing, and that they're kind of meshed together. You know, and that's the way I happen.
Can I have your cell number, because I don't have it?
Sure.
I mean, is that a city phone or?
No, it's not home. It's 667 5539 5528.
All right. It's okay if I call it on that. Okay.
Yep.
Sometimes it's easier to.
Yeah, it's fine. Nope.
Okay. So we got a criminal issue now. That was started on Wednesday. When was the start time on the criminal action? Yeah. a call, man, to call you back or something.
Thank you.
Ma'am, do you recognize that as a recording of the meeting on June 13, 2024 between yourself, Mayor Pro Tem Harden, and Chief Sims, which is the subject of charge number 4?
Yes.
Now, did you hear Chief Sims use the word slander or slandering in what we just listened to?
Counsel, is Chief Sims going to testify tonight?
Counsel, I'm not going to answer that. I don't know, and he may not. It depends on whether you get a case put on. Okay.
So,
and that, not even depending on that, it's like, I don't know. Why do you ask?
Okay.
Why do you ask?
I'm putting you on notice. 536070. A party who does not testify on his or her own behalf may be called and examined as if under cross-examination.
You can call him. You're perfectly free to call him.
You're playing this tape to provide comments that your client made with the idea that I can't cross-examine him.
You are at liberty to call him all night long.
Yes, sir.
If you want to, Troy. That statute says exactly what you says. So why are you asking me this?
Go ahead, please.
Did you hear him say slandering or slander, ma'am?
He did say it during that meeting. I'm not a witness to what he recorded and
So you're
he provided
saying
you.
that there's parts of the meeting that aren't on this tape?
he did tell us that was the justification for the criminal investigation.
And he didn't tell you what we just heard?
I'm not going to vouch that the entire meeting was given to you.
Okay. Well, let me ask you this. Where in charge 4 does it specify, as required, we went over the statute, an improper or unlawful purpose behind this alleged misrepresentation? What is that improper or unlawful purpose? Where is it in the notice? Or if it's not in the notice, do you even know what it is, allegedly?
For 4?
4.
Which notice are you speaking about? Sorry.
Well, you use the statute says that if you're going to say that a chief can be fired for misrepresentation, it has to be something that's stated that's false for an improper or unlawful purpose. Remember when I read that earlier? Yes? Yes?
Yes.
And you remember when your own counsel read it before I did, right?
Yes.
Okay. Now, what is this improper or unlawful purpose that's alleged in charge 4?
He misrepresented that we were violating or creating an obstruction of justice by asking him not to have a criminal investigation.
Yeah, that's the alleged misrepresentation. Now let's get to purpose. What is the alleged improper or unlawful purpose? Purpose of the person making the representation, Chief Sims. What was his unlawful purpose or his improper purpose so that this even qualifies under the statute?
He said we were obstructing justice, which our counsel earlier told you what those terms were to obstruct justice, which we didn't do.
Well, ma'am, do you understand there's a difference between saying something and then the purpose for why you say something, okay? I mean, I can say I want to adjourn early because I want to go have a drink in a bar. My purpose is to go drink in a bar. My statement is I want to adjourn early. You understand the distinction between a purpose and a statement?
I'm not going to pontificate about someone else's motives or why they did or didn't say something.
But you understand that in order for there to be a yes vote in good faith by any member of this council for this sort of a charge, you got to have proof of that. Not just that it was a misrepresentation, you got to have proof of the improper or unlawful purpose. I'm asking you, what is it and what proof exists? And if it's none, just share with us.
He was insubordinate by not agreeing to stop the criminal investigation of those employees.
And that's his unlawful purpose?
Being insubordinate is unlawful, yes.
So he was purposefully being insubordinate, and that's unlawful. And what makes that unlawful? It's just cause for termination if you disobey an order, right?
Yes.
Was he given an order?
He was given an order to stop the criminal investigation that had no justification.
In real time, he was given it, and we heard it, did we not?
Yep.
Yes? And he told you he couldn't do that, did he not?
He did.
All right. Well, the subject of the investigation was what he talked about as a false affidavit or false report, correct?
He did state that, yes.
Turn, if you would, please, to Exhibit 13 in the book, and just so we're on the same page, do you recognize that as the alleged, the report, the report that was being investigated as to whether it was false?
Yes.
Okay, now this is a form. You recognize this form, don't you?
I've seen it.
And it's a form that the city fire department uses, right?
Apparently, yes.
Okay. Now, turn, if you would, please, to tab 14 in the book. And my question to you is simply this. Is it your understanding, maybe you don't know anything about it, but I'm going to ask your knowledge, is it your understanding that under Missouri law, that a person commits the offense of filing false documentation if, with the intent to defraud, deceive, harass, alarm, or negatively impact financially, he or she files, causes to be filed, or attempts to file or record, creates, presents, or prepares with knowledge or belief that it will be filed, presented, recorded, or transferred to any municipal, county, district, or state government entity, division, agency, or offense, any of the following types of documents.
And I will object.
I'm not done with my question, Counsel.
Go ahead and finish it. Then I'll lodge my objection.
And that those documents include, if false, under Missouri law, statutory law, any state, county, district, municipal form or document. Doing so is a Class D felony. Is that something you were aware of, ma'am?
Now I will object. You asked her under Missouri law. She's not an attorney. She doesn't get to give a legal opinion. She can't give a conclusion. Furthermore, this is a field. We are not here to talk about whether or not these folks did it. We're here to talk about what Chief Sims did. And I'm directing the client not to answer. It's an illegal opinion that's a conclusory. Clearly, when you start the question, under Missouri law, do you think X? Not proper.
You're not going to tell me what your understanding is, right or wrong, on that subject?
No.
Because the attorney said not to, right?
Correct.
Okay. Well, then let's turn to the police manual. Now, you understand there is a police manual for the Lexington Police Department, correct? Mm-hmm. Yes?
Yes.
Now, as you were doing your get up to speed work when you got this job, did you go back and look at the minutes from February 9, 2021, when the subject of the police manual came up before this city council?
I had no reason to.
Well, turn, if you would, please, to Exhibit 15. I'll give you a reason to now, please. Do you see, if you go to page 2 of those minutes from the February 9, 2021 meeting, that the manual, police manual, was presented to the council, that there was a motion by Scott, seconded by Lynn, to approve the police manual as presented, and that motion carried by this council? Were you aware of that?
That's what it says.
Okay. Were you aware of that before today?
I have not gone back and read every set of minutes of every meeting for the city, no.
Now, you understand that the mayor can give certain orders to the chief of police, correct? Mm-hmm. Yes?
Yes.
But you also understand that the mayor doesn't have authority to direct the chief of police to violate a council-approved policy, right?
I will object. You have not admitted the policy in question that you allege has been violated. This recitation of the passage of that body is insufficient for that impeachment.
Are you done?
Yes, sir.
Do you remember my question? Let me ask you again.
State it again, yeah.
Sure. It's your understanding, is it not, ma'am, that although the mayor can issue certain orders to the chief of police, the mayor cannot direct the chief of police to violate a policy that this council has duly approved and which is in place. Correct, ma'am?
That would be correct.
All right.
I have no knowledge of him doing that, so.
Well, let's go to the police manual. Turn to tab 16, if you would, please. Do you see policy 600.2 highlighted there? Yes?
Yes.
Would you do me the courtesy of reading that out loud, please?
It's the policy of the Lexington Police Department to investigate crimes thoroughly and with due diligence and to evaluate and prepare criminal cases for appropriate clearance or submission to a prosecutor.
Do you have a problem with that policy, ma'am? No? Yes? No?
No.
And part of what the police officer is charged to do by a council-approved policy is to consider and gather evidence, collect any evidence, is it not? That's highlighted. You see that? Yes?
Yes.
Now, turn, if you would, to tab 17. What is the title of policy 6, of council-approved policy 600.5? Where the council, through this policy having been approved, is giving an instruction that the mayor can't trump, can override. What is the title of that?
Discontinuation of investigation.
And what does it say?
The investigation of a criminal case or efforts to seek prosecution should only be discontinued if one of the following applies.
A. What's A? The very first thing listed.
All reasonable investigative efforts have been exhausted. No reasonable belief that the person who committed the crime can be identified and that the incident has been documented appropriately. That assumes there was a criminal case to be investigated. There was no criminal case. Our legal counsel advised us to tell Mr. Sims to cease and desist the criminal investigation of those employees, and he stated that our attorney stated that the form you referenced was not a legal affidavit.
Counsel, I will interject here. The counsel in question is a member of my firm who's retained as the municipal prosecutor for the city of Lexington. In that capacity, he's not the civil city attorney like I am today. He's rendering a law enforcement opinion as to the actions of the police officer.
Are you done?
Yes, sir.
Well, ma'am, you remember the statute we looked at a moment ago that your lawyer didn't want you talking about? Remember that? That says if any sort of form for a city, if it's false, it can be a Class D felony if submitted, right?
It was determined by our legal counsel that was not an affidavit, and therefore there was no justification for a criminal investigation.
But the statute didn't just say affidavit, did it? When we went over it. You remember that?
Advising you not to give a legal opinion about this false affidavit statute.
Okay.
All right. Well, are you telling us that in your judgment as city administrator that, well, let me ask you a different question. Who is it that investigates crimes in this city that's employed by the city?
The police department.
And who is the chief executive of the police department, or at least was, or it is still today? Who is
Police chief.
And that's Troy Sims at the time, right? Yes?
Yes.
And he was, as you would interpret the city's policies that you're looking at here, 600.5, you would interpret that as being a direction by an authority higher than the mayor as to when an investigation is discontinued, correct?
What I can tell you is our legal counsel advised us to tell the chief to cease and desist his criminal investigation.
Well, all right, then let's talk about the whistleblower statute a little more. Turn to Exhibit 18, the next exhibit in order, please.
Prior objection.
This is where the city can get sued for taking disciplinary action against a public employee who discloses or says certain things, right? As you understand it, right? I got to say yes.
Yes.
Don't show up on our recording if we get it transcribed. And that statute says that no supervisor or appointing authority of any public employer, that means this council, shall prohibit a public employee from or take any disciplinary action whatsoever against a public employee for disclosure of information which the employee reasonably believes evidences, and then subsection A is a violation of any law, rule, or regulation. Did I read that right? Yes?
Yes.
And Chief Sims told you that he, as chief of police, was investigating a criminal violation related to this form that we talked about a moment ago, correct?
That was, yes.
That's what he said.
That was his understanding. We were told by legal counsel that there was no criminal standing to do that.
But you have no basis to believe, do you, that Chief Sims, the employee, did not reasonably believe that there was a violation of the law, that he was duty-bound to investigate? You have no reason to doubt that, do you, ma'am?
She just testified she does.
Counsel, I would love to cross-examine you. Would you
Yes.
please quit testifying for the witness?
Thank you for the comment.
You have no reason to doubt that in good faith he believed that he was investigating a violation of the law when he said what he said in this meeting we're talking about that is the subject of charge number 4.
We did doubt, that's why we got legal counsel opinion.
You doubted that he, in his mind, reasonably believed that it was a violation of the law to submit false information, whether it's an affidavit or not, false information to a public body.
That was his opinion.
Do you have any reason to believe it wasn't a good faith opinion?
I don't know what's in his mind or what he thinks.
Okay. Okay. But in any event, after he disclosed this information, as we talked about earlier, you put, what, 2 write-ups in his file, was it? You need your notes back from the mayor?
There was a couple, I can't remember.
All right, fair enough. We'll get those. I have not seen them. But again, you'd agree it's not a good idea for the mayor and the city administrator yourself, or the mayor sitting next to you, to discipline an employee in a manner that violates this whistleblower statute. You would at least agree with that in principle, would you not?
Counsel, I've objected multiple times. You keep asking the same question over and over and over. I'm directing my client not to give a legal conclusion.
And similarly, you would agree it's an even worse idea to fire a city employee after this sort of information is being disclosed, and indeed expressly because it was disclosed. Are you going to answer?
I'm advising her not to.
And you'll follow that advice.
Yes.
Well, let's go to charge number 5. Charge number 5 reads that you were insubordinate in returning a police officer to his former elevated rank and position, having been specifically instructed not to do so. Now, do you have any idea who this unnamed officer is?
David Cobb,
How did you learn that?
because he's the one that we rehired, and he was given, the chief was given explicit instruction on what terms to bring that officer back on staff.
But did you yourself ever see, after he came back, Officer Cobb's in a uniform that had chevrons on his sleeve?
I did not, but a member of the police personnel board did and reported it to me.
Who is that member of the police personnel board?
J.D. Hazen.
J.D. Hazen told you that he saw after after Cobb came back, he had chevrons on his sleeve, on duty.
He had a corporal distinction on his uniform.
Are you talking about chevrons or something diff?
Whatever they are that designate you as a corporal.
Well, wouldn't you expect that someone like Captain Alcar, for example, would know whether, when Officer Cobb came back, whether he came back in an elevated position or whether he came back as a base, bottom line officer on probation?
Counsel, you can't ask her to speculate about someone that's not here to testify. She's not a mind reader.
Would you expect that somebody in the chain of command would know whether that happened?
I don't know what Captain Alkire thinks or believes.
Well, would you turn, if you would, is that okay? Sure. Okay. Would you turn, if you would, please, in our book here to exhibit, would you turn on our book here to exhibits 19 and 20?
Mm-hmm.
Do you recognize who's in those photos?
Yes.
Who is that?
David Cobb.
And share with us where on his uniform it says that he's a corporal or something other than just a line-based entry-level officer.
I have no way to determine that those are his department-issued uniform shirts.
My question is, you've got a photo in front of you, 2 of them, right? Yes?
Counsel, does this have a timestamp on it?
Yes?
He could have put on anyone's uniform. It doesn't mean anything.
Well, I know you can speculate he could have come from Mars too, right? But I'm asking what you know, because you understand this is a serious hearing, do you not, ma'am? Yes?
Yes.
You understand it would be a serious error for this council to take action to fire this man unless a darn good record was made here today of exactly what it is that the firing is based on that would constitute just cause and hold on.
Now, hold on.
You understand that, don't you?
Hold on a second. That's a pretty serious accusation. When exactly was that photograph taken and where?
I'm not going to keep answering your questions like that, counsel.
I understand.
I can't certify that that's his uniform or not.
My question was different. On that uniform, is there anywhere you can point out where he is a corporal?
There's an American flag and there is a city police department logo badge.
So is that a yes, I can find something on it, or a no, I can't?
I don't know whose uniform he's wearing, so.
Well, let's say that it's a uniform from Kansas, okay? Can you see anywhere on that uniform?
In that picture, no.
Okay. And again, you yourself never saw him on duty or otherwise with chevrons on, right?
It was reported to me by a police personnel board member who is a retired police officer.
And is that person testifying tonight, do you know?
I don't think so.
Is that person present here tonight, do you know?
I have no idea.
Have you seen him or her?
Not today.
Was it a him?
Not today.
Was it a him? You said the name a moment ago, I didn't recognize it.
Yes.
I'm sorry, I'm not quite familiar with everybody yet. And what was that name again?
J.D. Hazen.
Did you have any discussions with Mr. Housen as to whether he should show up tonight?
I did not.
All right, let's look at charge number 6. Charge number 6 says you disregarded public safety by not placing an officer accused of a violent crime on administrative leave pending the outcome of an investigation into the officer's conduct. Did I read that right? Now, if you would be so kind, turn back to Exhibit 5 in the book that we looked at earlier, and specifically go to the page 16.03. Second page. On the second page there, do you see it?
Yep.
Now, this handbook again says that if you're going to have termination, that it's city council, but if it's going to be something less than termination, in other words, suspension, and that's what you're talking about here, right? Didn't suspend. In charge number 6, it says,
He was
by
put
not
on
placing...
He was put on administrative leave.
Yeah, that's suspending administrative leave. Do you see a difference there?
No, I was just helping what it said.
All right. So, an employee, the city policy says an employee may be suspended by the city administrator pending a decision by the city council, with or without pay, and then it says personnel actions less than termination may be taken by the supervisor with the approval of the city administrator. City administrator is mentioned there twice, right?
Correct.
So did you yourself have any involvement personally in this situation involving, whoever this officer is, it's unnamed with respect to paragraph 6? Your answer?
Upon legal counsel advice, we took it to the city council, and the city council voted to put him on paid admin leave.
Okay, but you were criticizing here that the chief didn't do that, right? I mean, read 6. Read it out loud.
He did, yeah, that's correct. He did not place the officer on paid admin leave on May 9th when he first became aware of the reported criminal charge or criminal conduct.
But if we look at Exhibit 5 again, he can't do that on his own, can he? He's got to have city administrator approval, correct?
On May 9th, I was not the city administrator.
I know, that's part of my point, but you understand that's the rules.
He, as the chief, he should have brought that recommendation to the city council
Well,
and the city administrator. And
All
maybe he
right.
did, I don't know, I wasn't there.
fair enough, you were not. So I think you're sharing with us, are you not? Who was your predecessor? I know everybody in the room knows, but...
Mark Odell.
And if Mark Odell was the city administrator, which he was, when this officer was accused of this misconduct, did you yourself ever talk with him to ask whether he consulted with Troy or vice versa over this issue?
No,
Do you know of anybody else that did?
not that to my knowledge.
Well, I'll ask you this then. If Chief Sims informed Mark Odell of the accusation against the officer, and City Administrator Odell told Chief Smith to let the officer work and see where the investigation turned up, what it turned up, where it turned out, you would agree with me that this charge 6 has no merit, correct?
And she's testified she wasn't here, she doesn't have direct knowledge of these things, and she can't give a legal conclusion.
But you would agree, just logically, that if you got a policy that says that for the supervisor, in this case the chief of police, to suspend or put on administrative leave an officer, that she or he, in this case he, can't do it on their own, they got to talk to the city administrator, right?
That's what it said, and I have no knowledge of what transpired.
And then I'm asking you a hypothetical.
I don't answer hypotheticals.
Oh, really? Well, I'm going to ask it anyway and see if you change your mind, okay?
Okay, go for it.
If Chief Sims informed Mark Odell of the accusation and City Administrator Odell told Chief Smith to let Officer Young work and see where the investigation, or Chief Sims to let Officer Young work and see where the investigation turned up, you yourself even would agree that in that event, if that's what happened, this charge 6 has no merit whatsoever under city policy.
I'm not gonna speculate on what happened before I was employed with the city.
I'm not asking you to speculate on that. I'm asking you if that is the facts.
You asked her a hypothetical. Plainly, it is speculation.
But you're unaware of anybody that even bothered to ask Chief Sims or Chief City Administrator Odell about this subject. That's what you're telling us?
She's saying she won't speculate about it.
You don't know of anybody that went, hey, I mean, called the man, and you have access to his phone number?
I do not.
You don't think that's in a city file because he was city administrator? I mean, is your phone number in your employee file?
I assume so, yeah.
And you would assume that the prior city administrators is too, right?
It may be. I'm not required to reach out to my predecessor.
Well, you may not be required to, but do you know of anybody, yourself or others, who did?
I do not. The answer is no.
Okay, thank you.
No matter how you ask it, the answer is no.
That's what I needed to make clear.
Okay.
All right, turn if you would, please, to Exhibit 21. This is also from the police manual. Now, the police manual itself addressed situations that involve domestic violence, does it not?
Yep.
And it says that there can be certain orders from courts that keep people who have a domestic violence situation from possessing a firearm. Do you see that? Mm-hmm. Yes?
Yes.
And it specifies in the city council approved police manual policies that all members have to, ensure that they don't become disqualified because you need to carry a gun just to cut through it, right?
That's what it says.
And it also says under reporting of the employee convictions that if you get a conviction which unduly restricts or prohibits that member from fully and properly performing his or her duties, that discipline can happen, including up to termination after administrative leave or whatever, right? Again, just to cut through it.
what it says, yep.
Okay. Now, do you have any information that at any time this involved officer for this charge number 6 was prohibited from carrying a firearm for any reason?
I don't have any knowledge of that.
Well, then let me ask you this. Can we agree, I assume we can, that anybody who is engaging in a form of child abuse, that is a horrible thing?
No doubt.
But it's equally horrible, is it not, to falsely accuse someone of abusing a child? Would you agree with that?
Yes, no one has been falsely accused.
And you have, well, you say that, but you have no evidence whatsoever that these charges against the involved officer had or have any merit, do you, ma'am?
Counsel, the charges were filed today.
The charges were filed today.
I'm still asking you, do you have any information that these charges have merit and that there was information available back when they originally was the subject of the discussions if they occurred with your prior administrator? Do you have any information as to what was known then?
I did not work here then. All I know is that the charges have been filed by the county prosecutor today.
Well, let me ask you this. Let's go to charges 7 and 8. Let's talk about the shooting range.
Okay.
Charge 7 says that you pursued a shooting range for the police department without the proper authority or permission from the city council and presented a proposal to the county for that purpose, again without proper authority or permission, which was inconsistent with the interests of the city council. Did I read that right?
Yes.
And then 8 says that you misrepresented material facts by claiming to have authority and permission to pursue a shooting range when you clearly knew that you did not have proper authority or permission to enter into agreements on behalf of the city or to formally speak on the city's behalf. Did I read that correctly?
Yes.
Now, did you yourself go back and look at any of the prior minutes to find out whether, in fact, this shooting range issue came before this council, different members some, but came before this council?
I did not. I was told that it was discussed and that he was told that he could investigate the issue or research it, but it was never, an actual vote was never taken by the city council to direct him to go to the county to put it on their planning and zoning commission, and the council never approved a firing range project.
Well, that's true. The council would have had to approve it, but the council was aware that the chief was exploring the idea. You at least concede that, will you not?
Exploring it, right.
All right. Now, if Mark Odell testifies that he had knowledge of the project and he gave okay to the city clerk for the $600 check to apply for the range with the county zoning and planning and zoning commission, would you have any reason to doubt that?
I haven't seen anything like that.
My question is, if he testified that that was what happened, would you have any reason to doubt it?
I'm not going to speculate on what I would think about his testimony. I haven't heard it.
Well, I just shared with you, if he said that he gave the okay for a check to be written, and it was kept up to speed by the mayor, and also they kept the city council up to speed all along, would you have any reason to doubt that?
Counsel, that's the third time you've asked. She said no.
I haven't heard a clear no.
No.
Thank you. Now, turn, if you will, to Exhibit 22. And do you recognize this as minutes from March 26 of this year, where if you go to the city administrator report given by Mark Odell, that the subject of the firing range is indeed even entered in the minutes. Item 5, page 3.
Yes.
Would you read what is said?
It says, fire range, Chief Sims is looking around the new water plant since there is 20 acres, which is the size the county requires. This could be a revenue source by allowing other agencies to use the range. There are no other firing ranges in the county.
Now, if the city administrator at the time shares that he did in fact give permission to apply for a permit,
That's not what it says.
I'm asking you if the city administrator testifies that he gave permission to apply for a permit, and that was for the range, would you have any reason to doubt that testimony?
I'm not going to speculate on testimony that has not been given.
So is the answer no, you would have no reason to doubt it?
That's not what she said. She declined to
That's
answer.
what I'm asking, though.
And you're not entitled to force her to give the answer you wish. She's declined to answer. You should move on.
I'm exploring what she knows. Do you have any reason whatsoever to doubt testimony, if it's given by your predecessor, that he gave permission to apply for the permit?
Once again, I'm not going to assume or speculate based on evidence or testimony someone has not given yet.
Well, all right, then let me ask you this. The permit we're talking about here is what's called a conditional use permit, is it not, ma'am?
I haven't even seen what you're talking about.
Well, I agree there's some ambiguity, but I'm talking about whatever the heck is the subject of these charges 7 and 8.
Do you have that document in here?
I have number 1, which is the charges, and I read aloud paragraphs 7 and 8. They're the firing range charges.
All right, so here's the thing. So the process, okay, 23.
Yeah, go to 23. That's fine. Thank you, Mr. Mayor, for that help. It's a conditional use permit we're talking about here, right? Mm-hmm. Yes? Yes? Mm-hmm. Say yes.
Yes.
Okay. And whose signature is on the conditional use permit that is the subject of these charges 7 and 8?
The city clerk.
Where do you see on any document Chief Sims authorizing something that would be an application or a formal thing happening? Do you see that? Do you have any single document that says that?
He put it on he was in contact with it's my understanding he was in contact with the county planning and zoning division or department and had that put on their agenda.
Okay. What do you base that understanding on, and why is it a problem?
So as a matter of process, in my experience, the city, for something like that kind of project or any project that would require multiple agencies, the city council would have had to have given formal approval to build or construct a firearms range.
We're in agreement on that. The final plans would have to go through the council,
and then
cost estimates would be submitted to them at a later date.
And then it would go to the county.
Right. But if you look at what Chief Sims actually wrote on this subject, turn to Exhibit 24. Have you ever seen that before?
Nope.
Did you look through the materials that relate to these firing range allegations before you signed that document that supposedly has just cause on it for firing a chief?
He never provided those.
Well, did you try to get them from the county? They're not far away, are they?
What?
No, I didn't.
Well,
he didn't follow proper process and protocol. He doesn't have legal standing to enter into a contract or agreement on behalf of the city council.
Nor did he enter into a contract or agreement on anybody's behalf, did he, ma'am?
He went above the city council and by taking it to the county.
Wait a minute. You just said he didn't have the authority to enter into an agreement. We are in agreement. He did not do what you just said he couldn't do. He didn't enter into any agreement on this subject or any other, did he, ma'am? That's related to these charges.
He circumvented the city council approval process.
The charge does not say he entered into a contract. It said he claimed to have the authority.
Well, you never heard him claim that, did you?
He didn't have the authority to take it to the county.
Take it to the county. You're telling me he can't share his thoughts on a subject to the Planning and Zoning Committee, the commission for the county in which he lives? Either as a chief or as an individual, is that what you're saying?
He does not have the legal authority to circumvent the city council's approval process of a project.
But that's my problem I went over at the beginning. That's a conclusion. Let's talk about facts. What did he do?
He put it on the Planning and Zoning Commission agenda for the county.
Well, okay.
That circumvented a legal process under state statute and city ordinance.
Which city ordinance are you talking about? And which state statute are you talking about, now that we're going to get into the law again?
The ones that talk about what the powers of the mayor and council are and what they are of the chief.
Well, I mean, is that all? You're not going to be more specific than that? That's all you know? Just some general powers?
Yep.
Even though the city's policies say that the chief is in charge of his department,
He
right?
acted outside of his authority by taking it to the Planning and Zoning Commission of the county.
Well, let's look at what he actually did. Look at Exhibit 24. You said you haven't seen that before, right?
Nope.
He shared his thoughts with the county, saying, first sentence, establishing a law enforcement firing range training facility can be crucial for a community's safety and security. Did I read that right? Mm-hmm. Yes?
Yep.
And what he actually did, if you go to I, he also adds under skill development that regular training boosts officers' proficiency in handling firearms, which is crucial for effective crime prevention and response. You see that? Mm-hmm. I highlighted it?
Yep.
And he also shared his opinion with the county. He disclosed that under enhanced public safety, well-trained officers can respond effectively to emergencies, reducing crime rates and improving activity. And then he goes on and says, law enforcement firing range training facility is essential for officer readiness and community safety.
Yep.
Do you disagree with any of those statements?
I don't disagree with any of those statements. There are multiple firing ranges in the region that can be used for training and are used for training.
And if that were the opinion of the city council, they would not have approved doing anything, right?
I don't recall they approved anything. That was only a city administrative report that the chief was looking into something. That's
And
not
the chief looked into something and shared these thoughts with the county, which you agree with, right?
It looks like those are his thoughts on his letterhead. Yeah.
Well, we'll look back at Exhibit 7, the whistleblower statute again. I want to make sure that's front and center in everybody's mind
And for the
before any further discipline would be taken.
And for the umpteenth time, this is not an appropriate inquiry for cross-examination. She's not a lawyer. She can't get legal conclusion, and I'm directing her not to answer.
Well, I'm going to ask my questions.
Yes, sir.
Again, you're aware that this city council cannot lawfully, under state statute, not something an ordinance could trump, prohibit a public employee from or take any disciplinary action whatsoever against a public employee for disclosure of information which the employee reasonably believe evidences mismanagement or a substantial and specific danger to public health and safety and a bunch of other things. You're aware of that, are you not?
And I'm directing you not to answer.
Okay.
Well, you will agree with me that what you've charged this chief with here, which involves this Exhibit 24 that he sent to the Planning and Zoning Commission, the county, you will agree with me that he's talking about public safety issues, correct?
It's on his letterhead, yes.
And you understand that if a statute says that you can't prohibit a public employee from talking about something, it means just that. You can't prohibit a public employee or take any disciplinary action because of it. Do you understand that, ma'am? Do you?
I'm not going to answer based on legal counsel's direction.
All right, well, let's talk about Charge 9 finally.
Awesome. Charge
Charge 9 says has been deemed insubordinate or found to be in violation of a written established, that's the statute. Charge 9 says you were insubordinate in allowing employees to interact and drive with their spouses on duty in patrol vehicles when you had been specifically instructed not to allow such conduct, which constitutes a disregard for public safety. Did I read that right?
Yes.
Now, who gave this instruction that's referenced obliquely in charge number 9?
I did.
And have you ever been the mayor of this city?
No.
Were you the mayor of this city when you gave that instruction?
No.
And if you want to see the instruction, just to make sure we're on the same page, turn to Exhibit 25. Is that what we're talking about?
Yep.
Yes?
Yes.
Now, turn to Exhibit 26. This is an ordinance of this city that has been duly enacted on the books since June of 1993. Do you see that? Exhibit 26.
Counsel, is that certified?
It may be certifiable.
I don't see it.
You don't see an Exhibit 26?
I see that. I don't see the July date you're referencing.
Oh, well, it's right below the section. You see it says section 21-6, Chief of Police, and then in parentheses it's got the ordinance.
Yep.
Since 1993. Now, if we turn over to the second page of that ordinance, under paragraph D, it says, does it not, that supervisory powers and duties, that's the title of D, is it not?
Yep.
It says the chief of police shall be the executive authority within the police department and in the performance of the day-to-day duties. She shall be subject to the orders of the mayor, M-A-Y-R only. Did I read that right? Capital M on mayor, right?
Yes.
Where does it say that the public administrator can give the chief of police an order to do anything in any ordinance or otherwise?
Can you state that question again?
Where is it in any ordinance or policy of this city where it says that you as the city administrator, not the mayor, can order your chief of police to do squat, to do anything?
I sent the email based on conversations I had with the mayor.
It's not my question. Where does it say in any ordinance that you can give the chief of police an order?
It doesn't say, well, I can direct the actions of the police officers. They do fall under my direction.
I am talking about the ordinance that governs the chief of police, and we're going to talk about a state statute here in a minute. But the ordinance says, does it not, that the chief is subject to the orders of one person and one person only, and that's the mayor.
Yes, and I was acting on behalf of the mayor under the direction of the mayor.
Well, now, is there any ordinance that you're aware of that says that you can become the mayor if the mayor says you can become the mayor and do the mayor's thing?
I wasn't becoming the mayor.
Well, you would understand. In fact, in your communication with the chief, read aloud where it says that the mayor told me to do this. That's Exhibit 25.
I did not put those specific words in the email, no.
Well, in fact, under state statute, you couldn't have, could you?
Mm-mm.
You understand, it didn't just the ordinance that says the mayor only. Even if another ordinance says you could act and direct the chief, you understand there's a state statute that would trump that, do you not, ma'am?
I haven't memorized all the state statutes in the state of Missouri.
Well, turn, if you would, to see if I can help with educating, to Exhibit 29. Do you see the part I've highlighted there?
Mm-hmm.
Now, this is one of those statutes that you made reference to where state statute says here's things that you can or can't do, right?
Mm-hmm.
At a city level.
Yep.
Yes?
Mm-hmm.
Yes?
Yes.
Read that first sentence up to the semicolon out loud of subsection 2, please.
The chief of police shall, in the discharge of his duties, be subject to the orders of the mayor only.
There's nowhere that it says a city administrator can act on the mayor's behalf in any statute or ordinance you're aware of, is there, ma'am?
Once again, I don't have them all memorized.
Well, you understand that for insubordination, failure to follow an order, it has to be an order duly issued by somebody that is higher up on the totem pole, right?
Again, counsel, you're implying that the statute has that definition in reading, which it doesn't.
Counsel, you can argue that all day long, and good luck with that.
Yes, sir.
Ma'am, you're under, you know of no authority by ordinance, by statute, that would give you the power to tell this police chief to stand up and salute, to report to duty at a different time, or to stand down from any activity? Because you're not the mayor, correct, ma'am?
I am not the mayor.
Well, you did get a response that same day from Chief Sims, did you not? Mm-hmm. Now, it's a little hard to read because it's fine print the way it got printed, but turn, if you would, to Exhibit 27. Do you see Chief Sims' response there?
Yep.
And again, I've got it, I did a cut and paste and made the text larger on here for my notes, but it says, I wanted to address any concerns and misunderstandings regarding our ride-along police. The policy approved by the City Council in 2019 is attached. To date, there are no reports of misconduct related to this program. Nevertheless, I will remind our command staff to remain vigilant for any potential policy abuse. Regarding Captain Alkire and Officer Alkire, I would like to clarify their roles and contributions to our department. Officer Alkire is currently the only reserve officer and serves as a juvenile officer for Ray County. Her availability is limited to every other weekend, which coincides with Captain Alkire's schedule. Their combined presence staffing levels during weekends, as without Officer Alkire, we would be reduced to a single officer on duty. There have been no complaints or misconduct against Captain Alkire or Officer Alkire. Both officers have demonstrated professionalism and dedication, making them invaluable. Please feel free to reach out if you have any other questions or require further clarification. Did I read that right, ma'am?
Yep.
Is there anything in that response that you responded to or that you would disagree with today?
That was his way of saying they're going to keep doing what they've been doing.
My question is there anything in that response you disagree with?
I disagree with his justification for allowing it for the reasons we've stated earlier, that it can alter their judgment on calls, and it can pose a risk to them as the officers and to the citizens.
And he responds that he needs to have more than a single officer on duty for public safety. Does he not, ma'am?
It doesn't mean it has to be her.
But he's expressing his good faith belief, is he not, that this is not a problem that's working out well and we need it for public safety. Is he not, ma'am? As you would interpret what he said.
I believe that was his justification to continue following the practice they've been following.
And again, if we go back to the whistleblower statute, you're aware that this council cannot prohibit a public employee from or take any disciplinary action whatsoever against a public employee for the disclosure of information which the employee reasonably believes evidences mismanagement or a substantial and specific danger to public health or safety, which is indeed what Troy Sims was talking about. Correct, ma'am?
I'm advising you not to answer.
Okay.
That's all I have for this witness.
I would ask to testify from Troy Sims. Mr. Sims, I don't know what you're more comfortable at the podium or standing. I'll have Carla swear you in.
Are you going to put these back so I can be able to read? Do you promise to tell the truth and nothing but the truth?
I do.
Sir, can you hear me all right?
Yep.
Please state your name.
Ronald Troy Sims.
And you're the Lexington Police Chief, correct?
That's correct.
All right. What I want to do is go through some of these allegations. Allegation number one. On May 29th, 2024, the police personnel board declined to hire someone that you'd recommended. Is that right?
That's correct. No, that's wrong.
Tell me
Police
what's wrong.
personnel board agreed to hire
I'm sorry, that's right. The recommendation, but the board declined to do it, right?
the council, yes.
Yes. You're not happy about that, right?
I'm okay with it now. They hired
At
me.
the time, you were not happy.
No,
You expressed that verbally, did you not?
no,
We've heard testimony that you profanely yelled at them. Do you disagree with that?
I disagree with that.
Did you use profanity?
No,
Did you yell at them?
no,
Did you raise your voice?
Are we talking about something that is in closed session? Because I
I'm
can't
asking
say,
you.
no, I can't say anything there about closed session.
And I
You're
disagree.
trying to fire me on down the list there for saying I'm saying something out of closed session.
And I disagree with you.
Now
I'm asking
you're
you.
asking me to say something that was said in closed session.
Are you done?
Not,
Did you raise your voice?
no,
Okay, next. On June 11th, you were not happy about a hiring decision, is that right?
about hiring him, I'm sorry.
On June 11th, you were not happy about a hiring decision, is that right?
Yes, correct, yes.
Okay, during that, did you raise your voice?
No,
Did you do it? Did you raise your voice more than once?
no,
You're sure.
absolutely.
On or about June 11th, did you subsequently discuss the contents of a closed session with your employees?
Absolutely no.
Have you ever, at any time, ever revealed any detail discussed in an executive session to your employees?
No,
Not once.
not once.
Did you tell the mayor pro tem and the city administrator on or about June 13th that they were obstructing justice?
No.
What did you accuse them of doing?
I wasn't talking to the city administrator. I asked the mayor if he understood what obstruction of an investigation is, as it was on the video.
Tell me the definition of obstructing a government operation under Missouri law.
Interfering with any kind of investigation.
Do you know what the statute says?
Yes, I do.
What does it say?
It says if you interfere with an investigation, it's obstruction.
I disagree with you. Does it say you have
Okay.
to have a violent act?
Do you have to have a violent act?
Yes, sir, that's what I'm asking you.
No.
It's in the statute. Does it say you have to physically interfere?
No,
It's in the statute.
it doesn't.
All right. You were not happy about the police personnel board's review of this employee candidate, correct?
No, I was happy with police personnel board.
You weren't trying to stop them?
Trying to stop them from what?
The police personnel board's reviewing this candidate. You're not happy about that, correct?
No, I'm okay with it.
Your purpose in telling them you're obstructing justice is so they would back off, right?
No.
You're
that
sure
police-
about that?
No, I didn't say anything to the police personnel board.
You're not trying to stop this review. Is that your testimony?
That is my testimony, yes.
Did you ever have Officer Cobb back on duty wearing a corporal's uniform?
Not to my knowledge, no.
Did you ever see him wearing one?
Not to my knowledge, no.
Did he work in the corporal's desk?
You're going to have to identify what a corporal's desk is. I'm not sure what
Did
it
he
is.
sit at the desk the corporal sits at?
We don't have assigned desks.
Did he sit where he formerly sat?
Probably, yeah.
So if someone testifies, I saw him after he was brought back running around in a corporal's uniform, that person's wrong.
That person is wrong, and he wasn't promoted to corporal. There's a process to give somebody a promotion, and we didn't go through that process.
You're absolutely sure he
I
never
am
once was
one-
on duty?
I am 100% sure. You
Yeah.
can ask the command staff.
Okay. You were opposed to an officer who was being investigated for a crime being put on administrative leave, were you not?
No,
You're glad he was on administrative leave?
yeah, I was fine with it. That was a decision, and we followed policy, and we went with the policy.
No complaints about it?
No,
Okay. You wanted a shooting range for your police department, didn't you?
sure,
Did you go talk to the county about it?
yes,
Did you discuss the price?
no,
Did you discuss particular real estate?
no,
Did you talk about a zoning permit?
no,
Did you say, I would like to negotiate with you?
no,
You never claimed to make a statement on behalf of the city at any time?
no,
Not once?
no. I didn't even fill out the permit. City Hall did.
You allow married couples to drive the same car on duty, do you not?
No.
They've never once driven together?
I'm sorry, what do you mean by married couples? What are you
The
referring to?
Alcars, they're two police officers, they're married, they're in the same car at the same time on duty, correct?
Yeah, and I can't find a policy that goes against it.
That wasn't the question. They were allowed to
That
do
was
that.
the question. I can't find an ordinance or a policy that goes against
I'm
it.
asking you a fact question.
I'm telling you a fact answer that
No, you're not.
there is no policy that that the alcoholics can't ride together. And if I tell them not to ride together, now I got to tell every officer that they can't ride together. So that's a discrimination right there.
All right, we'll make this simple. I'm not asking you if it's illegal to run a stop sign. I'm asking, did you see a car run the stop sign? Have you ever seen the cars riding together in the same car on duty?
I will talk slower. Okay? I will not discriminate against any officers, period.
You're refusing to say whether you've seen that event occur.
Yes, I've seen them, but I was not given a direct order.
Great. In your memo, it talks about shaft shortages. Explain to me how their being in the same car has anything to do with one guy being on duty. Why do they have to be in the same car together?
They don't have to be in the same car together.
I agree with you. Do you think it's a good idea for a married couple to be on duty in the same car?
Again, what's the policy? What's the ordinance that they're breaking?
You think it's a good idea for a married couple to be on duty in the same car?
I don't see any problem with it.
Not at all. Outstanding. Thank you.
These two officers are great officers. They're the best officers we got. I have no problem with these two officers. They make great decisions. There's never been any complaints of misconduct or anything.
You allow officers to be with their spouses in the same car that are not married, correct? Or excuse me, not both officers.
No, unless they go through the ride-along program.
Okay, let's suppose they do. Do you allow that?
By our policy, it has to go through the sergeant first.
Have you ever known that event to occur? An officer have their spouse in the car on duty in a patrol car?
Only if the ride-along policy is followed.
So when we go to court about this, I'm going to tell the jury, you refuse to answer my question. Do you know of an officer ever being in a car on duty with their spouse?
I will talk slower again.
Please.
Okay. Only if they go through the ride-along program. Then they are allowed to go to ride along.
Has a spouse couple gone through the ride-along program?
Yes.
And who are they?
We've had Officer Williams that is no longer with us. She had her spouse ride with her. We've had Officer Young, his spouse rode with her. And Officer Alcar.
Okay. Those folks that went through the program, did they actually ride together?
Yes.
Okay. So, cutting through it then, you have personal knowledge that couples have ridden together on patrol cars while on duty?
Yes.
All right. Do you think that that is a prudent decision?
Again, what policy or anything has anybody broken?
I'm not asking you that. I'm asking your opinion.
And I'm telling you that. There is no policies or anything broken, and I'm not going to discriminate against someone just because they're a spouse of an officer.
So let me get this straight. You're of the opinion that having one spouse in the car does not affect their situational awareness?
No.
It's your opinion that having your spouse in the car does not increase the chance that misconduct will occur on duty?
No, you can't speculate.
It's not your opinion that having your spouse on duty might interfere with your ability to respond to an emergency?
No.
It's your opinion having your spouse in the car while on duty does not put that person in a greater peril or danger in the event of an armed encounter?
Absolutely not.
Very good. In the course of our discussion today, it is your opinion that you answer only to the mayor, is that correct?
That's what the policy says and the ordinance says, yes.
It's your opinion that you do not have to listen to this council, is that right?
Absolutely not.
Explain that to me.
If the council wants to give me an order, I'll be more than happy to follow through with it.
I appreciate you saying that. Your attorney's gone to some pains to imply that only the mayor can direct you. You disagree, right?
Under ordinance, yes. Under policy, yes. The mayor is my supervisor, yes.
If this council decides to direct you to do something, you certainly acknowledge their lawful authority to do so.
Only if it's lawful, and only if it goes for ordinances or policies, and especially if they tell me to stop an investigation, I'm not going to stop an investigation.
The investigation in question was to commit which exact crime?
Filing a false form.
I'm sorry?
Filing a false affidavit or form.
So that was a sworn document then?
Yes.
And what statute is that?
That I don't recall. I
Did you
got it.
produce a PC statement on that?
No,
Did you forward that to the prosecuting attorney for Lafayette County?
no.
So your investigation did not merit charges.
No, it ended before that. Yes.
Why did it end?
There was a conflict with, I felt that it was more of hearsay, and the person that wrote the affidavit, that it come to, I would have to show intent on that false affidavit.
But at the end of the day, you didn't think you could prove the case.
At the time of the investigation, yeah, it's worth looking into, absolutely.
I'm asking at the conclusion. You did not submit a PC statement.
We can talk about conclusions all night, but yes.
And I intend to.
Yes, okay, knock so out. Yeah.
Now, the prosecuting attorney for the city of Lexington is the person that brings charges on municipal offenses.
Yes,
The Lafayette County prosecutor brings state offenses.
yes,
All right, so there is a suspicion of criminal activity that you can't prove because of hearsay and other things, right?
sure, yes.
And they say you don't need to pursue that further, right?
No,
The allegation is you can't tell me to stop investigating, correct?
that is correct.
So it is, in your opinion, improper for the city to say, this case that you can't prove, you need to stop digging.
Absolutely, it's improper.
Why?
Absolutely, 100%.
Why?
Why? Because I have a duty and I have an oath to look into every crime that is reported or every investigation. I have to fulfill that investigation.
And you always dig to the absolute length in every single case, right?
Absolutely,
And you don't stop until you're sure you've got your man, right?
absolutely.
Including in child abuse cases?
Yes,
So you've never decided not to pursue an investigation for child abuse against a policeman?
that is correct.
Never once put it on hold?
Never.
Never once made an administrative decision, I'm not going to advance this to the prosecutor?
That's correct.
Ever?
That's correct.
You're sure?
Absolutely.
Thank you, sir, for your time.
Yeah, you can get by the mic. Okay. You can share it. It'll be an interview here. Man with the mic. No, we're not going to sing. You don't want to hear me sing. Just a couple of things really briefly. You heard opposing counsel object a couple of times to these recordings when he referenced the legal term foundation and whether they were in fact a true and accurate representation of what was said.
Yes.
And you were here on the various recordings, I won't mention them by exhibit, but they're in the record, were played.
Yes.
And are each of those a true and accurate representation of what was said in the reference meetings?
Yes.
With respect to the tone that you had during those conversations, how would you, if you're able to compare that to your normal tone and the tone you use speaking on other occasions, for example, with the mayor?
I would say normal.
Finally, you talked about the ride-along program, and everybody that is listening here tonight may not understand what that is.
Sure.
Would you take a moment and explain it, and that'll be my last question.
Sure. The ride-along program is developed to be a community service tool. We have a form and a process that you have to go through, a policy, it's all drawn out in policy. Anybody, so you're more than welcome to come out if you want to do a ride-along. You sign the form and you understand the limitations of what you can do during the ride-along program. You have to stay in the passenger seat. You cannot get out at any time. We usually try to limit it to 2 to 3 hours at the most because officers are busy. They do have to do reports and things like that. So there is a criminal background check that you have to go through, and then it goes through the sergeant. He signs off on it, and then it goes up to command staff as well. So that's kind of basically our ride-along program. And it is a policy that the city council has approved.
Thank you, sir. My final witness will be the Mayor Pro Tem, Mr. Harden. Carl, if you swear him in. Folks, I know we've been going for some time. This is my last witness.
Do you promise to tell the truth and nothing but the truth?
I do.
Can you all hear him okay? Sir, please state your name and position in the city.
John Hardin, Mayor Pro Tem.
Sir, you've been listening to all the testimony today?
Yes.
So I'm going to make this a little more abbreviated. On May 29th, 2024, did Troy Sims yell at you?
Yes.
Did he use profanity?
No.
Did you deem his tone, manner, and bearing to be insubordinate?
Yes.
Were you present at the council meeting on June 11th?
I was.
Was Chief Sims unhappy about the hiring decision?
Yes.
Did he repeatedly scream at you?
Yes.
On June 11th, 2024, did you have reason to believe that Troy Sims was going to go back to the police station and repeat what happened in closed session?
Yes.
In fairness, you didn't actually hear him repeat anything,
No, I did not.
but your clear understanding of his instructions was that was what was about to happen.
Yes.
Did he tell you, you're obstructing justice if you tell me to back off of this?
Yes.
It was your opinion because the municipal prosecutor has said there's no crime here, there's no need to do that.
Repeat that again.
Is it your opinion the municipal prosecutor had advised there's not a criminal case here, that's why you told him to back off?
Yes.
Did you think he was trying to bully you? Don't get in my way or I'll charge you with a crime.
Yes, I did.
Did you ever use violence?
No.
Ever threaten him physically?
No.
Ever use physical interference?
No.
Did you ever have any information that Officer Cobb, upon his return, was running around dressed like a corporal?
I did not.
Were you aware of a directive that he was to come back only at the entry level?
Yes.
Are you aware that if an officer was investigated for a violent crime and that Chief Sims disagreed with putting him on administrative leave?
Yes.
Did you believe that officer should be put on administrative leave immediately?
Yes.
Did you believe the fact of a potentially violent criminal with the authority and weapons of a policeman might constitute a public safety threat?
I do.
Do you believe that pursuing a shooting range was something that the council instructed him to do?
No.
Did you ever authorize him to negotiate about getting a shooting range?
We did not.
Ever authorize him to enter into contracts on behalf of the city?
No.
Ever authorize him to speak on behalf of the city?
No.
Do you think a shooting range is consistent with the interests of the city?
No, I do not.
Do you think a shooting range engages cost, liability, and environmental concerns that are contrary to the city's interests?
Yes.
Do you think it's a good idea for folks on patrol duty to have their spouse in the car?
No.
Do you think that those couples did in fact drive around and patrol in the same car?
Yes.
Counsel, please.
Mr. Mayor, if you'd been the first person to testify, I would have taken you through everything that I asked the lady seated to your right, but mercifully, I'm just going to ask you a couple of quicker questions. Fair enough, since it's getting later in the night? Okay?
Yeah.
You talked about being screamed at or yelled at on June 11, and that's the subject of which charge number, sir? Number 2, isn't it?
Yes.
Would you read charge 2 aloud?
Yes, you were insubordinate with the members of council at public meeting on or about June 11th, 2024, in which you repeatedly screamed your disagreement with hiring decisions that was not yours to make.
Now, you understand that public meeting that's referenced was recorded, and we put it in here, I believe, as Exhibit 7 for this record. Correct, sir?
Yes.
And would you disagree if I represented to you that if we played that whole darn thing, start to finish, from pledge up through you're announcing the meeting adjourned, the public meeting, that's what he's charged with, that you're not going to hear any screaming or other words uttered by this chief of police for this good city?
Yes, in the public meeting.
And you understand that's what's been charged. There's no reference to anything in a private meeting and before this council, is there, sir?
It was during an executive session.
Well, but that's not what we're talking about here in this charge, is it, sir?
And I will disagree with that opinion.
You understand public meeting to mean private sessions? Is an executive session a public meeting?
No.
Have you yourself in executive session ever felt more frustration and expressed it than maybe you would have if the cameras were rolling out in a public session?
No.
Never have, huh? Always the same tone in the closed meetings as you have right now? Yes? No? Maybe.
Maybe.
Well, okay. You never instructed this chief of police to put anybody on administrative leave, did you, sir?
I never, what again?
Did you yourself instruct Troy Sims to put anybody on administrative leave?
Yes, I did, yeah.
You yourself
I was at
did?
the meeting, yes.
And when did you tell, and read which charge it has to do with, that you instructed Troy Sims to put Officer Young on administrative leave, or for that matter, anybody else?
Yeah, I don't know what number, let's see here. I didn't have my numbers. Number 6.
Read that aloud.
It says, you disregarded public safety by not placing an officer accused of a violent crime on administrative leave pending the outcome of an investigation into the officer's conduct.
And you yourself never gave such an instruction, correct? You yourself.
Well, we put him on administrative leave.
I'm talking about communications where a person such as yourself opens their mouth, takes a breath in, makes words form in the English language that constitute an order. You yourself never gave this instruction about administrative leave or about riding in cars or any of this stuff, correct? To Officer Sims, Chief Sims.
Are you talking about 6?
I'm asking you my question, whether you ever
You had me
gave...
read number 6.
Well, I wanted, if you thought you had given such an order, you yourself would, you know, I mean, didn't have to do anything with Officer Young, did it? You yourself, sir, the mayor. Simple question.
I believe it went to council.
My question is, did you as the mayor ever instruct Troy Sims to put an officer on administrative
No.
leave? Okay, thank you, sir. And finally, you referenced that you can't have a chief of police enter into contracts on behalf of the city, and we can be in agreement on that, can we not, sir?
Yes.
But you don't have knowledge at all of any contract that was entered into where Troy Sims purported to have the authority to do it, do you, sir?
No.
That's all I have.
Ladies and gentlemen, that concludes the city's evidence. Council, do you have some witnesses you'd like to call?
Yeah, we'd like to call Mark Odell.
Okay. My thought would be to have, let you do that and then make a quick closing statement. You can make a closing statement and I think we'll be done. But I will yield the floor to you.
Yeah, is Mark here? Oh, come on up.
Mr. Odell, what makes more sense for your for microphone?
I'll share. I could share this one.
I need to be sworn in though, right?
You do. And don't swear back at him.
Okay.
Go ahead, Carl.
Do you promise to tell the truth and nothing but the truth?
Yes.
All right. Introduce yourself and let us know what your prior position was.
Mark Odell, city administrator for almost 5 years. I retired on May 23rd, right before my 66th birthday.
And what are you doing these days?
I'm supposed to be enjoying paradise instead of being here.
I want to take you briefly through these charges. There's a couple of them I think you may have some information on. Charge 1 is saying there's insubordination on about May 29, in which there was profanity. Did you yourself hear such profanity?
No, I've never witnessed that.
Well, how would you describe our chief's demeanor when you've had interactions with him during your course as the public administrator and otherwise?
Well, I was on board when we hired him.
And I said public administrator, I mean city administrator, sorry.
He has always been very professional, always looking out for the interest of the city, trying to move the police department forward. Of course, he's advocating for the police department, but generally speaking, he's been a very, very awesome, good employee.
And I'll interrupt you there, counsel, for the record. I'll object. This is improper character testimony. What this gentleman thinks about his generic character and his mode of behavior is not relevant. He is a fact witness on that particular date, I will concede. But his commentary should be excluded that he's a wonderful person.
Well, and
Wonderful employee.
yeah, thank you for clarifying that testimony by opposing counsel. Did you ever see him disclose anything that he shouldn't have that was confidential because it was in a closed session or otherwise?
Absolutely not.
Did you ever see him be insubordinate and fail to follow a lawful order issued by the mayor of the city?
No, absolutely not.
Did you know of any material facts that he ever misrepresented for any purpose?
Absolutely not.
Now, charge 5 says you were insubordinate in returning a police officer to his former elevated rank and position, having been specifically instructed not to do so. And there was some testimony earlier that I think that had to do with Officer Cobb.
Mm-hmm.
Yes?
Yes.
Were you around when Officer Cobb came back, or you already?
No, I was already retired.
Have you seen Officer Cobb, though, around the city?
Yes. Yes, I have.
Do you know the difference in terms of a uniform for a person who is a corporal or a sergeant or on up the line as opposed to a baseline officer?
Yes, he's got some of the stripes on his uniform.
If you're the higher up.
Yeah.
Have you ever seen Officer Cobb, once he came back, in anything other than that picture that I put on the screen, those two, where he didn't have any chevrons or any identifying information suggesting he was other than just a line officer?
No, I'm not.
Now, charge 6 says that you, referring to Troy Sims, disregarded public safety by not placing an officer accused of a violent crime on administrative leave pending the outcome of an investigation into the officer's conduct. And although not specified in the charge, we heard some references here to a particular officer, Young, correct?
Correct.
And what role with the city, if any, did you have when that occurred?
Okay, so that was right toward the end of my tenure. Sometime the 1st of May, Troy came in. He was really upset about the charges. We talked about it. I believe we might have even had the city clerk in the meeting. And because we really didn't have anything other than just some very vague accusations, I advised Troy that I thought the best course would be to contact the Highway Patrol for a couple reasons. One, we generally don't investigate our own employees. And secondly, I thought that would be the appropriate organization or the appropriate law enforcement agency to handle that. And at the time, we just didn't have anything other than just a very vague allegation.
And you saw what we put on the screen earlier and discussed, a city policy on what has to occur before an employee, including police officers, could be suspended or put on administrative leave. Did you not?
Yes.
And your understanding of that policy is that the city administrator has to acquiesce, has to say yes, right?
That's correct.
Or stated differently, the chief or supervisor, he's a supervisor, the chief in this instance cannot unilaterally, in other words on his own, place that employee on administrative leave, correct?
That's correct.
There is a process that's outlined where the supervisor, in this case Chief Sims, has to go to the city administrator and discuss the matter.
Yes, and he did do that.
And in that regard, did you ever suggest that this, or acquiesce in putting this particular involved officer on administrative leave, knowing what y'all knew at the time?
No, I suggested we contact the Highway Patrol and let the investigation get started.
And is that in fact what occurred?
Yes, it is. Yes, it is.
Now, let's talk about charges 7 and 8. You heard those read. They both involved this shooting range, correct?
Yes. Yes, that's correct.
Now, with respect to the shooting range, is that a subject, what discussions, if any, did you have on that subject with Chief Sims?
Okay, I can clear that up pretty quick. The mayor and I thought that it was, the mayor at the time, David Goodlow, and I thought it was something worthwhile to look into. I recommended.
Guys, folks, if you see me kind of limping here, I've got a little upper body paralysis from old fart syndrome. I call it in my neck. It's my, so I have trouble holding some stuff up sometimes. I apologize for that, but I have a good friend here who will help be man with a mic now.
Yes, Troy came in, talked about the shooting range. The officer's been having to drive quite a ways to target practice, and it was a very important topic for me because we'd had a couple of incidents of shooting. We'd had a couple of shooting incidents in the last year and a half, and we'd had an incident that was kind of scary out at the high school, and I was worried about the proficiency of our officers with firearms, and Troy was suggesting maybe we could put a firing range out at the water treatment plant where we own 20 acres. I was kind of doubtful about it, but I think my words to Troy was, I said, run it to ground, and if it looks something doable, then we'll take a formal proposal to the city council. And so one of the things that's different about the county process than the city, we have informational meetings at our planning and zoning, and we have one of the old-time P&Z people here, and we let people come and present something or ask questions with no charge, no nothing. But the county is a much more formal process, and so in order to kick this can down the road, we had to find out exactly what were the county requirements going to be for a firing range. And so that's why we had to go to planning and zoning, to the county planning and zoning. We're not entering into any contracts or any of that. We're just trying to get the information for what the county would require. And my thought, our fallback position might be, if we couldn't make it work at the water treatment plant, that there's a hunting club just down the road that's got hundreds of acres, thousands of acres, that maybe we could put one there. But our first preference would have been to do it on our own property. So he was working under my instructions with agreement with the mayor.
Now, in order to present it to the council, of course, the information that you summarize has to be gathered, right?
Right, exactly.
And you saw, we talked about it earlier, we mentioned, I think we had it marked it as Exhibit 22, a council session from March of this year, March 26, in which you brought the council up to speed on what was going on.
Right. Yes, briefly, yes.
And what pushback or contrary instructions or other objections, if any, were voiced by the council with respect to what you and the chief were doing as you explained?
At that time, there was absolutely no objection, and I wouldn't expect there to be at that point because we just didn't have enough information. But there was nobody saying, oh, don't do this, this is a dumb idea, you know, so I felt good about us proceeding with continuing to research it.
But as you said, there was no contracts entered into.
Absolutely not.
In fact, by law, as you understand it in Missouri, you can't have a contract until it gets council approval and gets signed.
Ultimately, the council has approval for almost everything.
And you saw there was a conditional use permit, we marked it as Exhibit 23, that was signed by the city clerk.
Yes, I don't know that I saw that at the time. I'm not sure when that was, but yes, I've seen it.
Okay. And
that's just part of the planning and zoning process. Our planning and zoning, our city planning and zoning issues temporary use permits, special use permits, all those kind of things. So that's a normal. So we were just asking for conditional use of that 20 acres.
And with respect to what you were doing, would it be fair and accurate to say that you and Chief Sims were working in good faith together?
Yes, along with the mayor.
And along with the mayor at the time, and who was that, just for our record?
Mayor David Goodloe.
And so with the mayor, who's the immediate supervisor of the chief, yourself, was there anything, were you close in this? I mean, every step of the way?
Up until I left, yes.
And during the time frame that's mentioned in these charges, was there any time in which Chief Sims wasn't working with your approval and with the mayor's approval?
He had not ever left the reservation.
That's all I have.
Mr. Odell, is it?
Yes.
I'm going to grab hold of that microphone for me. Can you hear me all right, sir?
Yeah, pretty much.
Okay. The child abuse situation, the allegation only, that came from a state reporting agency, the original complaint. Is that your understanding?
I did not know that.
Okay, that's news to you. Are you aware if there's a police report that was not forwarded to the Highway Patrol or to the Lafayette County Prosecutor in the city's files?
No.
Have you ever seen photographs of physical injury?
No.
Would you, in your opinion, if someone showed pictures of physical injury, would you describe that more than a vague allegation?
Absolutely.
Yes, sir. When you're working on this shooting range, you gave some orders to Chief Sims?
I told him to run it to ground, get all the information, the cost, et cetera, and we would take a formal proposal back to the city council if it looked feasible.
And as city administrator, I would agree with you. You're allowed to give that kind of direction. You have no problem with that?
Nope.
You're not the mayor of Lexington.
No.
You weren't at the time?
Nope.
But to be perfectly clear, I think you directing that city employee to go look into this is perfectly appropriate. Do you agree with me?
Yes.
Very good. That's all I have, sir. Thank you for your time.
Is Captain Alcar here? Come on up if you would, please. You're going to need to be sworn first.
Do you promise to tell the truth and nothing but the truth?
I do.
Please introduce yourself just so our record is clear.
Captain Fred Alcar.
And what do you do?
I'm a captain at the Lexington Police Department.
For how long?
4 years.
And are you familiar with Officer David Cobb?
I am.
How so?
He was an officer at the PD.
And what roles, supervisory-wise, if any, did you have relative to this particular officer?
Well, I'm in his chain of command.
You're above him, correct?
Yes. Yes.
And do you recall that he was with the city, left for a short period, and then came back?
Yes.
The day he came back, are you aware of what rank he held?
Patrolman.
And patrolman, is that different from a corporal or sergeant?
Yes, it's a non-supervisory position.
And was he treated as an entry-level employee? Was he on probation, anything of that sort?
He was on 6 months probation to start.
Same as if he had started?
Yes.
Have you yourself, how often do you see this particular officer since he's come back?
On a regular basis.
And on a regular basis, or even one instance, have you ever seen the man falsely represent himself as being a rank other than patrolman?
No.
Have you ever seen the man have chevrons on his sleeves?
No.
That's all.
No questions for you, Captain. Counsel, any other witnesses?
There is nothing else based on this record to respond to.
Yes, sir. All right, folks, we're at the finish line here. I'm going to give my little closing statement. I'll let counsel do one, and then we'll see about a motion. I know it's late. We've been going for a while. I appreciate everyone being cooperative and non-disruptive. That's very appreciated. Get my outline here. Ladies and gentlemen, the point here, the theme tonight, is a police chief that's simply unwilling to work with the city. As reflected in the allegations presented here, Chief Sims believes that he answers to no one. That is profoundly wrong. A police chief wields significant power. but that power is subject to the control of the elected body, which he simply refuses to work with. Council, anything?
Well, I want to thank you all for listening and for following through with the exhibits that we went over. And I did that so that the council could make as informed a decision tonight as possible. What I'm going to say is there may be some folks, in fact, I've heard reports have already announced which way they may go on this. But I'm going to share with you that I'm going to call on your higher self, on your higher power, on your higher good, to think about what you've heard tonight, to think about what's in the best interest of the citizens of this community. You do not have a renegade police chief. There would have been one charge, and it would have been a real serious one, and there would have been something to back it up, and you just don't have that on any of this stuff. It's like taking a handful of sand and throwing it at the wall, and it doesn't stick. I'm calling on you all to think about what happens. We've already gotten a situation where there's violations of the various statutes, not just the police chief statute, it's not just the Administrative Procedure Act, but it's the State Whistleblower Act as well. You've got discipline. This council hasn't, I know there may be insurance, but that doesn't mean that you should do something that's going to make matters worse and dig the hole deeper, and it's just not in the best interest financially of this community to terminate what is actually a very good public servant and employee. This record cannot hold up if presented to a court under the statutes that I've cited, and I'll share with you all, it shouldn't, in your heart of hearts, it shouldn't hold up as well. So this motion that will be made now, both on the procedural infirmities and the lack of any substantive grounds, should without a doubt be denied.
Mr. Mayor, if you would.
Okay, I'll seek a motion to terminate Troy Sims' employment as Lexington Police Chief for just cause. Okay, Beth.
Did someone make the motion?
Yes.
Go ahead, say the microphone.
Councilman Hanson
Okay.
made the motion. Need a second?
Second.
Councilman Kramer seconds. Need a roll call vote.
And the way this vote will work, a vote for yes means a vote to terminate.
All right.
Why
Thomas?
don't you give her the microphone?
Well, I can't do it.
Thanks, Charlotte. Appreciate you.
Thomas? Yes. Ryan? Yes. Chandra? Yes. Mike?
No.
John?
Yes.
Daniel? Beth? Yes. And Tom?
Yes. Mr. Mayor, we need a 7-1. Mr. Mayor,
7-1.
motion to adjourn.
Motion to adjourn. Got a second?
Second.
Okay. Do we need?
Thank you all for coming. Thank you very much.
Okay.